Hey everyone, sorry about that. Had the wrong thing on the screen. How is everyone? Happy Friday. I am so glad this week is over. It seemed like it was forever, but we have made it. We have made it. So we are going to today look at the remaining testimony for the defense and the verdict, which was handed down yesterday, as well as interviews that the prosecution gave, the defense gave, and also media spoke with the father of the two children who were killed in this incident. So the testimony this will be a fairly long live. So we may take a break in between, but we're going to get right into this because, as I said, a lot happened yesterday. So, hey, Velda, thanks for being here. Sinner, thanks for being here. And I see we have a few more people in the bushes. Thanks for being here, everybody. I do appreciate it. All right, so we're going to get started.
Michigan is now in session. Judge Daniel White now presiding.
People of the state of Michigan versus Marcella Chester.
We ready to proceed?
Yes, Your Honor.
All right, bring the jury.
Judge, hang on. Sorry. Well, we talked about this chambers already. We got to put this on the record, Judge. We have people object to defendant's expert witness being called. We were not providing proper notice under the court's orders, nor does it comply with the court rule. We provided no notice, no written summary, which is required under 6.201. 6.201J allows the court to prohibit the testimony in the court, and people v. Butler upheld that as an appropriate remedy. We have no idea what this gentleman's going to testify.
I'm going to slow it down just a little bit. I had it on 1.2, but I feel like it's a little too fast. So I'm going to try 1.1.
Put this on the record, Judge. We have people object to defendant's expert witness being called. We were not providing proper notice under the court's orders, nor does it comply with the court rule. We provided no notice, no written summary, which is required under 6.201. 6.201J allows the court to prohibit the testimony in the court, and people v. Butler upheld that as an appropriate remedy. We have no idea what this gentleman is going to testify to. He may tell us the earth is flat, therefore our machines are calibrated improperly.
Judge, if I may reply, it is informed that we needed one until we found out very late that our expert that we had retained, Dr. Rose, MD, would not be able to testify because the court's regular procedure is that it can't be by videotape, live by videotape, by Zoom or otherwise from where he's at. And as you're well aware, I filed a motion, and as you're well aware in the motion, it sets forth that he suffered from a very serious
Argument to the court.
very serious issue. And the court's well aware of it. I'm not going to duplicate everything on the record or be repetitious. And that he can't fly. He was not able to drive. He's in his mid to late 70s. And you could have blood clot in his brain.
Okay, we know all that.
Okay, all right, Judge. So knowing that, and then plus, I did not receive any records concerning the toxicology until February 10th. Okay, so they didn't timely and ready to give me records. So then I received. So then we had to schedule. We had to run and get another expert to review everything. Tell me over the phone what he thought of it and anything that's beneficial.
Well, let me ask you: is there a report?
There is no report. He did not do a report.
All right.
And experts do not have to do reports. And he's not going to be relying on a report, or else, as I informed the court last Friday, I believe, that as soon as we get a report, we would immediately email.
Okay. Here's the thing. The notice was given. It was late. Lots of things have been late in this case. But I do think it was some unusual circumstances. The original expert witness was not available or couldn't appear for whatever reason. Notice was given. There's no report. You wouldn't necessarily know what he's going to say anyway unless there was a report. And of course, I would order that if there was a report, I would adjourn the matter so that you could review it, kind of review it with your witnesses, but there's no report. So I'm going to overrule your objection and we'll bring him to the
Last thing, Judge, just for the record, our expert is in the courtroom for this testimony.
I have no objection to that, Your Honor.
Okay, thank you.
Thank
I
you.
have one matter put on the record just to make it part of the record and take a minute.
Quick.
Thank you, Judge. We talked in chambers about this, and that is Dr. Gard, MD, is the treating physician, Ram Gard, and it's G-A-R-G. He's out of Bloomfield, treating physician out of Taylor, Michigan. He currently, as the court's aware by motion, has 35 counts against him for holding a criminal enterprise and prescriptions unlawfully given. That's out of Wayne County Circuit Court Judge McCarthy. That's a trial date of June 2nd of this year. I had asked for an adjournment in court tonight. Michigan Court of Appeals supported this court and said that there was no need because there's no emergency, which I don't get why. So then anyway, we tried to serve him as her treating physician. And we've tried to serve him with the West Bloomfield Police Department where he resides. Last known, all the furniture is pretty much missing out of the house. They tried several times, the police department and a process server. Then I did as an officer of the court, represented that I did a mail trace. There is no change of address, so somebody's picked it up as mail. So we attempted all of that. Lastly, Judge, as a desperate means, is I had served professionally attorney Prasad, P-R-A-S-A-D, who's listed in Wayne County as his attorney at 4190 Telegraph Street, 3000 Bloomfield Hills, yesterday at 10:09 a.m. in person to say in company of and to get Dr. Ram Gard here at 9 a.m. this morning. I don't see Dr. Ram Gard. I called his name. I looked for him. There's a picture I have of him, and he's not here. I've not heard from the attorney.
Okay.
So I
made a record.
I wanted to make the record, Judge.
Okay.
Thank you very much.
All right.
Very quickly, Judge, I know this is driving you nuts.
Yes.
Mr. Columbus accused us 5 minutes ago of a Brady violation. I want to make a record that there is no Brady violation here. The documents he received from the lab were received by him on February 10th. His demand for discovery was filed February 3rd, received by us February 4th, well in compliance with the court rules. I just want to make a record.
All right, the record is clear.
Just very quickly, is Brady says you don't have to make a demand. If you've got any evidence at all, you got to put in the evidence.
All right, we've made a record. Let's bring him.
Yeah, of course, the podium here.
Which is your witness in the
Who's in the back? Yes, he'll be here.
Good morning. You may be seated. I know that you guys were all on time. We have not been on time. I apologize for that. Sometimes things are outside our control, but we're ready to go now. Your next witness, Mr. Close.
Thank you, Your Honor. May I go get my witness, please? Thank you very much.
Yes, I do. Sir.
Watch your step.
Okay.
Would you state your name and spell your last name for us, please?
First name Okori, O-K-O-R-I-E. Last name Okorocha, O-K-O-R-O-C-H-A.
Thank you.
This is
Sir, how are you currently employed?
I'm a forensic toxicologist.
Okay. Can you give, by way of background to the jury, your education, formal education?
I have a bachelor's degree in biology. I have a law degree. I have a master's of science in pharmaceutical sciences with a specialization in forensic science. And I have a second master's degree in forensic toxicology.
And You currently, what is your job encompass currently? What do you do?
The forensic toxicologist reviews the data produced by analytical instruments. In my case, it revolves around blood, breath, hair, saliva, urine testing.
And how long have you been doing that?
18 years.
And did you ever give expert testimony in a courtroom?
Yes.
Approximately how many times have you provided expert testimony?
Over 700 times in 55 of the 58 California counties, 25 times in 25 different US states, and in Germany and Japan.
And were you qualified as an expert in those locations?
Yes.
And did you ever give testimony and qualified as an expert concerning any U.S. military service personnel?
Yes, in Germany and Japan.
And in what setting would have that been?
Court martials.
And what were the allegations?
One of them was that the soldier was impaired while off duty, and his foot was taken off by a train. So in order to get his benefits, we needed to establish that he wasn't in fact impaired. The second one was the Navy one in Japan. That was a breath alcohol test.
And were you qualified as an expert in those cases?
Yes.
Have you been qualified in blood testing in labs and hospitals to give testimony?
Many times.
In breath testing?
Yes.
In the breath testing involving alcohol?
Correct.
In chemical analysis of blood, have you been declared an expert in that area?
Yes, correct.
Approximately how many times as a chemical analysis of blood have you been qualified in a court as an expert?
I would say over 400.
When it concerns the issue of driving impairment, have you been qualified in courts on that issue?
Yes, I have.
And approximately how many times?
Several hundred.
Have you been qualified in federal court ever?
Oh, yes.
And drug use and effects, have you been qualified in that area in courts?
Yes, prescription drugs, drugs of abuse, over-the-counter drugs, drug interactions.
With regard to field sobriety tests and chemicals that may affect sobriety tests or dexterity tests, have you been qualified in that area that you've given testimony?
Yes, and I have formal education in field sobriety tests.
How long ago would have that been?
2014 or so.
And do you do updates on that?
Yes, I teach the
You
course.
teach it?
Yes.
So you teach courses in forensic and related areas?
Yes, and in field sobriety tests, blood testing, breath testing.
In what setting do you teach?
For the State Bar of California, I also teach for various criminal defense organizations.
When you say the State Bar of California, would that be that people attend that are defense attorneys and prosecutors
And judges.
and judges?
Yes.
And have you been declared an expert in forensic toxicology?
Yes.
And that's in different courts in the United States
Correct.
and in Germany and Japan, correct?
Correct.
And general toxicology, you've been declared an expert, found to be an expert by a U.S. court?
Yes. General toxicology is usually it's 50 or so times. That's things that are contaminating the water or poisons and such.
Hair testing you've done?
Correct.
Pharmacology, you've been declared an expert in those fields in U.S. courts?
Correct.
And the issue of impairment by drugs or alcohol, have you been declared a expert regarding toxicology of that?
Correct. Drugs, alcohol, or alcohol and drug interactions.
And you've given expert testimony in the case of Derek Rose?
Yes, MBA.
Who is that? Derek? I'm not a sports person. Who's Derek Rose?
He was the former NBA MVP.
And did you give ever any testimony as an expert in the George Floyd case?
No, I was a consultant on the case, the civil case, which I was working on settled prior to the trial or testimony.
And as a consultant, were you asked for your expert testimony or expert advice?
Yes, and I relayed to the attorney what the attorney needed to know.
And then the last case is, it's captioned Hawaii versus Denise Dixie Villa, Villa. What was that case?
That was a baby manslaughter case involving Benadryl.
And were you qualified as an expert for the court there?
Yes,
I'm looking at your curriculum vitae, fancy word for resume, and it says you're testified in over 850 jury trials. Is that correct?
correct.
In 55 different California counties,
Yes,
24 United States federal courts.
I think he said all that.
Did you say 24 U.S.
I
courts?
think he said 25, but 25 other states.
Thank you, Judge. And you received a Master of Science in Pharmaceutical Science, specializing in forensic science from the University of Florida in 2012.
correct.
I would like to have my witness as an expert.
Judge, we bought you.
Yes, you may.
Mr. Okorocha?
Yes, sir.
All right. Sorry if I get that wrong. You said you have a bachelor's in biology.
Correct.
Where did you obtain that degree?
California State, Northridge,
When would that have been?
99.
And so after you graduated in 1999, did you go right to graduate school
I went to law school.
immediately? When did you start law school?
Yes, it was the fall following graduation.
So that would have been 1999.
Yes,
And when did you graduate law school?
2002.
When did you go to get your master's?
2010.
What did you do from 2002 to 2010?
I worked for the federal government, U.S. Department of Health and Human Services as a civil rights investigator, and then I worked as an attorney.
You worked as an attorney? You worked as a defense attorney?
Yes, for 3 of the 22 years I've been licensed.
Specializing in drunk driving cases, I assume?
For the 3 of the 22 years, I focused on that.
Where was that law school located?
It was in Costa Mesa, California, Orange County,
And where did you go to get your master's?
University of Florida.
So undergrad and law school in California, master's is in Florida.
Yes,
How long did you live in Florida?
I didn't live in Florida. You can do a lot of the work remotely. You take the exams and certain classes in person.
So you got your degree from an online university?
I wouldn't call it online because you're mostly doing research, but yes, it's remote.
Were you in class in person
Yes, for some of the classes.
for all of the classes?
No,
How did you do labs from California to Florida?
sorry.
How did you do your lab requirements? How did you meet lab requirements if you were living in California and your classes were in Florida?
The forensic toxicological analysis is not lab technician work. It's the analysis of the data. The laboratory technician work is simply filling up vials, putting them in a carousel and pressing a button.
Something tells me most chemists would object to that assessment, but I'll move on. The undergrad, how much lab work did you get?
General chemistry, organic chemistry, physics, microbiology, plant biology. There's more. I'm just not.
Do you work in a lab now?
I work for a lab. I'm not a technician, so I don't fill up the vials, but I analyze the data for a laboratory.
What lab do you work for?
AK&A labs.
Does that lab comply with the International Organization of Standards regulations?
I'm not in charge of compliance. A lot of what I do is also reviewing things from other labs for our lab, but I don't know.
Have you ever tested blood on a gas chromatograph?
I've tested over 10,000 samples.
When did you do this?
I've worked for various labs since 2000, from 2011 up until COVID.
Do you conduct testing still?
Only if I'm covering for somebody. I'm not a technician.
Are you a certified forensic alcohol analyst?
I'm not sure what that is.
Take that as a no. Your most recent professional experience then would be from prior to COVID?
Well, my lab technician work would be prior to COVID. My most recent professional experience would be this week.
Are you a licensed toxicologist?
There are no licenses for toxicologists, at least that I'm aware of.
Is your lab that you work with accredited by anyone?
I don't know the accreditation process. We have labs we send things out to that are accredited for other things. I'm not sure what the labs are accredited for.
What did you review in preparation for today?
It's really more cross than it is right here.
Okay, I'll move on.
Hang on a second.
Have you ever testified in the state of Michigan before?
No,
What protocols govern blood collection and testing in Michigan?
I did not review the blood protocols. I reviewed the analytical chemistry data.
So you don't know what rules or policies are used and implemented in this state? Do you know who implements these policies?
No, the policies aren't relevant to what I'm analyzing.
All right. And Judge, the people object. I don't think he's qualified to testify in the state of Michigan. He doesn't even know what governs collection or testing of blood.
All right, well, the court does determine that this witness has been qualified as an expert witness over 700 times in 25 different states, in Japan and in Germany. Has a significant education, also has a significant practical experience. Accordingly, the court does qualify this witness as an expert in forensic toxicology.
Thank you, Your Honor. May I proceed?
Yes.
Thank you. Dear sir, could you, again, just say your name?
Okori Okorocha.
Okay, all right. And you reside where?
El Segundo, California. It's by Torrance, south of LA.
And you received certain records that were sent to you, is that correct, concerning this case?
Correct.
And they were more of toxicology type records and things like that, right?
Correct. Laboratory records.
All right. And you're not, a lab tech is somebody that stores, let's say, blood or accepts blood from the police department and then stores it. Is that correct?
Correct. Stores it and then tests it. No.
Okay. All right. That's a lab tech. All right. It's sort of a simple procedure. It's more simple, correct?
Yes, we have lab techs that don't have any college education, for example.
All right. And you had opportunity, your job or being an expert when you testified is to interpret the results after they've been obtained through testing devices. Would that be a fair statement?
Correct.
And that's where all of your expertise surrounds, not drawing blood or storing it, but analytical.
Correct. I am familiar with the procedures for mixing the blood once it's collected and what you're supposed to do with it once it's collected.
Okay. Well, whether it's a blood draw and placed in a vial in California or in Michigan, does it change fermentation or anything? Or it's the same blood?
Your Honor, this is a leading question.
Well, I got to ask the question.
Well, the question is whether it's a leading question. Why don't you just try it?
Okay, all right. When you give testimony, prior to giving testimony, do you look at the toxicology reports?
Yes, and the laboratory data supporting whatever reports were generated.
Do you just look at the one page that says this is the result and that's it?
No, anyone with Microsoft Word could generate that. It's the data that supports it.
And can you inform the jury what data you looked at prior to coming to a conclusion concerning this case and this blood type?
There are various lab worksheets and then various graphs. The actual blood sample is depicted on what's called a chromatogram. which is a visual depiction of what was found in the blood.
And we did go through this with state of Michigan people that testified yesterday. But I want to ask you, just to see if we're sort of on the same page of what they said. And that is, when blood is extracted from an individual and it's put in a tube, let's say state police or government, or you want to, preserve it or save it for testing in the future, is there a preservative that's usually mixed with it?
Yes, and nationwide, everybody uses the same tubes, the BD or Becton Dickinson, and they are supposed to be gray top tubes with preservative and anticoagulant.
Okay, and that's a private company that does that, correct?
Correct.
And it's all the same? I mean, in other words, throughout the states?
Yes,
So they have the contract with all the states as far as you know?
apparently so, or they're the only ones that make that kind of tube. I don't know.
Okay, and that would be Michigan and California both?
Yes, or any other state.
Okay, and I don't know toxicology inside out. I didn't study it. And the jury and the judge, can you please explain what would be in this tube and what purpose does it serve?
So the potassium oxalate would act as an anticoagulant because when the blood, if it clots, the alcohol follows the water portion of the blood and not the red blood cells. So if it clots, you get a higher concentration. So you want to fend that off. Secondly, it would have sodium fluoride, which is intended to inhibit microbes such as bacteria or fungi from converting blood sugars and other substrates into alcohol. But it's an imperfect process.
Okay, and when the tube is opened prior to putting the blood in,
Oh, it isn't opened, the needles.
if the needle goes in,
Mhm.
the needle is in the air, in the tube, then the needle goes into this tube with a protection on it, and then blood is put in the vial, correct?
Correct. And typically for forensic purposes, you would want to wipe the top of the blood tube you're putting it in.
So you're not putting something that can be contaminated right into the blood. I don't know. What would be the reason of why I was wrong? What would be the reason why you wipe it?
Because it's easy to insert microbes such as bacteria and fungi into the sample, and it doesn't take a lot of bacteria or fungi to be able to alter the sample.
I presume from what you're describing, it's very, very sensitive, and you have to be very careful.
Yes, all biological samples change immediately coming out of the body. So it's just like when you buy milk at the store, you get the one with the furthest expiration date. It's stored properly, but you know it changes.
And how should, if the blood is put in like you described into this, is it 2 vials or 1?
Most jurisdictions collect 2 vials just in case there's a problem with one because it's an imperfect process.
Okay, and once that happens, the person that draws the blood, what is supposed to be done with the tube? Just put right in the box or what?
No, the tube is supposed to be inverted approximately 8 to 11 times. So if this pen is the tube, you're going to turn it.
Record reflect that the witness is holding on to a pen that's about 8 inches long.
John.
Thank you.
So you would take the tube, you would turn it completely upside down and then bring it back. And you're going to repeat that process 8 to 11 times.
Okay. I'm going to show you a pen. Record reflect that I'm holding a pen maybe 8 inches long between my 2 fingers. And I'm going to just wiggle it back and forth and not actually turn it upside down 8 to 11 times. If I wiggled it once or twice, would that be enough to do a proper mixture of this chemical balance at the bottom of the tube?
No, not per the manufacturer guidelines. And the manufacturers have an interest in having the most robust tubes they can have. And even they say you need to go through that procedure.
And if a person does not mix it, for lack of a better word, mix it properly, this 10 or 11 or 8 or 10 times, what could happen?
The anticoagulant could not properly mix in the blood sample. And so you can have coagulation or the red blood cells clumping together, or if the preservative is not mixed all the way through, you can have fermentation, microbes converting sugar, blood glucose and other substrates into alcohol.
And what happens when fermentation? Do you want fermentation to happen in a sample?
No, you usually do everything to prevent it.
And what's the reason why?
Well, the fermentation, you're converting blood contents that are not alcohol, such as glucose, and you're converting them into alcohol. So not only are you losing blood volume, you're increasing alcohol, which can make the blood alcohol level go up significantly.
And if it's tested after that, would the test be reliable for
No.
measurement of alcohol in blood?
No, fermented blood would not be reliable for blood alcohol concentration.
Is there an analogy with regard to preservative or milk or anything like that? We talked for a minute today.
The preservative is imperfect, and depending on what microbes are present, there can be significant changes, but there are always going to be changes. That's why you draw it, you put it in a refrigerator freezer, because that slows down whatever biological processes are going on, and you mix it to try to control it, and then you want to test it as soon as possible.
And what does the state testified that at times there's a walk-in refrigerator and samples are put in. Why is there a refrigerator? Why is there refrigeration?
Because biological processes happen a lot slower when you're in a refrigerator freezer, as opposed to heat. Heat speeds up the chemical reactions.
Would that cause a fermentation at all to speed up?
Yes, it would cause any biological process to speed up.
And fermentation, what would that do to a sample, the accuracy
Um,
of the blood alcohol level?
It could make it go up significantly. In one study, they found that it would go up to a 0.10 in 1 day or 24 hours.
And if the fermentation is not shaken or inverted several times, would that also affect and cause to go up much higher?
It makes it far more likely.
So if the preservative, let's just say it's not mixed properly and it's not refrigerator kept cold, you're really going to have an inaccurate result. Would you agree?
That potential is a lot higher.
And you don't want that normally, right?
Correct.
You want people to follow the test so you have an accurate result, correct?
Correct. Proper procedures.
And these procedures are not only for California or Michigan, am I correct?
Correct. There's nationwide standards, national standards from the U.S. Department of Health and Human Services, the Society of Forensic Toxicologists, and the American Academy of Forensic Sciences.
And are you aware of all of that? Are you aware of all that standards?
I know them pretty well. They're over probably 200 pages. So I don't know every single detail, and they go into very specific areas that I don't necessarily deal with.
There'll be no test today on that. Do you use that in your practice of analyzing data?
Yes.
And after having an opportunity to review the data that was applied to you, supplied from the prosecutor, how many pages was it?
Over 300 pages total.
Okay. And was there anything unusual when you looked at the data and you were analyzing these pages of results or raw data?
Yes.
What are you looking for to see? What would you look for in the data to make sure that proper testing was done, or maybe it wasn't done?
Various things. In this particular case, I noted that there were other compounds in the blood sample that would not be there without fermentation.
And what would be the name of those compounds?
I'd have to look. The most significant one was acetone, which would be nail polish remover.
Not that nail polish remover was put in there, but is that something that's put in nail polish remover?
Yes, that's what nail polish remover is. the blood sample would have tiny amounts of these volatile organic compounds such as acetone, and the amount of alcohol produced when even you have a tiny amount of acetone can be 10,000 times as much.
And does somebody that wants an accurate result from blood testing toxicology, wants an accurate result, would they want acetone being found in their sample?
No, you would want to throw out the testing because acetone's not found in human blood.
Well, there was some testimony yesterday that you can have a little bit of acetone in the sample and it's okay.
I would strongly disagree.
Have you ever been told that it's okay to have some acetone in a blood sample and it's accurate 100%?
No, and there were other volatile organic compounds in there as well.
Where would those compounds originate that you saw? How would they originate? From what?
In a blood sample, the only way you would find them is fermentation, unless somebody put those, ran all those things in the instrument and there was a lot of contamination or something.
Unless somebody intentionally put them in, it happens through fermentation. Is that what I understand?
Yes,
And fermentation could occur non-refrigerating the sample prior to testing and/or the chemical compound inside the test tube is not shaken properly.
or it can happen even with refrigeration.
Okay. And if it's not refrigerated, would that be like an expiration date on milk, but you leave it outside and it tastes sour prior to?
Yes, correct. It would speed up the expiration of the milk.
So even though the expiration says, April 1st, if you left it outside in the sun prior to, expiration doesn't matter what it says, right?
Correct. All those biological processes happen a lot faster.
After analyzing the data that was supplied to you from the state toxicology department, do you think that the result that is allegedly obtained as 0.18 of that blood level, that's truly accurate?
No, because there were several volatile organic compounds present in the sample.
And all of that combines to not giving you an honest and accurate sample.
It gives you a result that is not the same as it was when the blood was drawn.
Do you know if the second sample of the vial of blood, there were two?
Yes.
Two, right? And that's what was testified to yesterday, there's two.
It was run twice. I don't know which vial it came from, but it was run on two different what are called columns.
Do you know if the second vial, if it was ran on that, does it show any testing on that in the records you've looked at, the second vial?
I don't know about the vials.
Okay.
I just remember the columns, and it was run on both columns.
That's what I was gearing the question to, that if there's two, which there was testimony of, and tests are done on one, do you know if the second test tube or vial was tested at all from looking at the reports?
Yes, there were two tests.
So each one was tested,
Correct.
or at least it looks like that?
Correct.
Okay.
Or at least two columns.
Okay. And there could be two columns in one test, correct?
There usually is two at a minimum.
And then it was described to us yesterday by a toxicologist from the state that the process is, what you said earlier, you push a button, you put the blood sample in, you push a button, and then it just operates on its own, correct?
Correct. It's completely automated. So most people would usually run it overnight so that you don't have lab personnel checking Facebook or sitting around.
And that's exactly the testimony was, that it's ran overnight and it's approximately 7 hours. Does that sound right?
Yes.
And the toxicologists, when they're running this test, they don't have any personal involvement, or they're not touching the blood or the sample or anything. It goes into a machine to keep it as clean and impartial as possible, right?
Yes, and it's all automated.
And if somebody's at a hospital, in your opinion, professional opinion, if somebody's at a hospital, would it be more accurate testing to take their blood there and have the hospital test it than to get it, shake it, it might ferment, refrigerate, not refrigerate, wait 2-3 days, and then have it tested? Would it be better just to have the hospital more accuracy, take a blood sample right then and there?
Objection, Judge, this is a leading question.
No, it's leading, Your Honor, but I'm asking him his opinion.
I'll allow the question.
Thank you.
The hospitals have their own inaccuracies just because it's done very quickly. They can't wait 7 hours necessarily for, get test results back, because the person could be.
So, but you wouldn't have the fermentation taking place. Is that correct?
Correct. And you always want to test it as soon as possible, regardless of where you get it from.
So would it be more accurate to if the hospital do it than let something ferment?
All things being equal, yes.
Your resume, I've had marked as Exhibit 1, and I believe, I'm going to move for it to be admitted, but I believe it's stipulated to already.
Defendants 1 is admitted.
The CV, thank you. Is that true and accurate as to your?
It's admitted.
Okay, thank you, Judge.
Did you get it to my clerk, please?
And after reviewing all,
Yeah, I'm gonna, for the record, any defense exhibits should be letters. This is defendants A is admitted.
are you marked that, Judge? Or would you like? me to
I'm
mark it?
changing.
All right, thank you, Judge.
Thanks.
And in your professional opinion of all your years, of all your testing that you've done, of all the cases of, I don't know, 1,000 cases altogether, and all the forensics you've done, in your opinion, toxicology wise, your professional opinion, are these with the acetone that developed a true and accurate result of the blood test?
No. And there were also other volatile organic compounds. And if we put the chromatograms up, I can point out the issue.
Okay. Do you have that at all in your laptop or anything like that?
I have them electronically in my iPad.
Your Honor, may he look at his records, please, to refresh his memory?
If that'll refresh your memory, sir.
Yes, Your Honor.
Thank you, Judge. Please, sir, let me know if you're done.
Okay.
Please take your time to refresh your memory fully. That shows in their testing.
There is acetone and isopropanol.
Okay, that's the one I had problems pronouncing yesterday, the second one. Not that it's relevant, but tell the jury about those compounds. Are those normally in your blood?
No, you wouldn't have volatile organic compounds in human blood. Alcohol is a volatile organic compound, but the only reason you have it is if somebody consumes alcohol. But normal human blood wouldn't have acetone and isopropanol.
And if normally you would have, because somebody consumed alcohol, would that, how does the fermentation affect that, or other compounds or acetone?
Well, the fermentation greatly increases the alcohol level that you have present. It can make it drastically higher, or it can make alcohol where there's no alcohol. So they take blood samples and they see if they ferment, and the blood alcohol levels can go from 0 to a 0.10 in one day.
And if there's all these other chemicals, could it go up higher?
Well, the other chemicals are just telltale signs that fermentation occurred, because fermentation is sort of involves the byproducts of fermentation. So you'll see those sort of things.
But you're absolutely positive before this jury that those results are not accurate according to your opinion, professional opinion, and according to the records you viewed from the state. The 0.18 would not be accurate.
Correct. It would not be accurate for the time of the time the blood was taken.
Okay. And there's no way of knowing what would be an accurate amount if these samples were polluted or fermented.
There's no way to determine how much fermentation occurred. If you have some volatile organic compounds, it was far greater than the amount of the volatile organic compounds, but you can't place a number on the increase, or if it went from 0 to whatever number you have, or it went from a lower number to a higher number.
And if somebody had a regular, I don't know, 6 ounce or whatever it is, glass of wine between 11 and 12 or 11 and 12:15, and a blood sample was taken, let's say 3 hours later, or 6 hours later, would it be accurate as what's being tested because acetone is in there or fermentation may or may not be occurring?
If there's acetone present in other volatile organic compounds, that's evidence that fermentation occurred.
And it's just not good. You said, like, I don't know, drinking nail polish or having nail polish.
Correct. Nail polish remover.
Nail polish remover. And it's very, very strong. Am I correct? Alcohol base.
Sorry, what is?
It shows an alcohol base when you're testing, when you have this acetone.
Correct. There's a significant amount of 10,000 times as much alcohol created as the acetone.
Now, can you go back and prior to testing, take acetone out of the sample?
No.
Once it's in there, it's in there?
Correct. Taking it out wouldn't do anything to the alcohol produced.
Okay, so once the alcohol is there, it's there even if you could extract the acetone, its damage is done, so to speak.
Correct, because the acetone is part of the process in
Okay.
fermentation.
And, I looked at your resume, or when I was speaking of it in front of the jury, qualifying you, is you've also been involved in breathalyzers or, formerly data masters and things like that at the station, somebody blows into a tube and then it registers 1 or 2 amounts that may be of alcohol level. Am I correct?
Correct.
Okay. There was, that wasn't done in this case. Are you aware of that?
Yes.
Would it have been a good idea to have done that?
The more data points you have, the better understanding you have of your test results.
And if there was fermentation or any pollution of these samples, you sounds like common sense that you'd have the breathalyzer at the station, those results, right? If everything was working good.
Right. Those would not be prone to the fermentation errors.
Not at all, correct?
Correct.
Okay. I don't have any other questions, John.
Cross. Mr. Okarocha, does acetone ever occur naturally in the human body?
If it does, I'm unaware of it, and the body has to get rid of it very quickly because it's toxic.
At what level is it toxic?
I don't know offhand. It would vary for each person.
You said you reviewed the lab reports and the data points from the GC.
Yes.
What else did you review in preparation for today?
There were various laboratory documents such as worksheets and chromatograms indicating the acetone. There were controls, calibrators, calibration curves, reference samples.
Did you review the police reports?
I received them, I think. I don't think I reviewed them. I was only working on the toxicology part.
Did you review the body camera footage of the blood draw?
No.
You cited a study where the blood alcohol level went up 0.10 in 24 hours. What study is that?
It was by Bloom, BLUME, and Lakatua, LAKATUA.
Did you bring that with you today?
I have it electronically.
You have it electronically. Can you provide a copy to us?
Electronically.
What other publications have you relied on in preparing for your testimony today?
I guess the Becton Dickinson manufacturer guidelines. But the things I'm talking about are they're sort of common knowledge. There wouldn't be an authority on them.
This practice is accepted not only in the state of Michigan, the way the blood is drawn, the way it is transported, but throughout the country. You testified, correct?
There are national standards.
So, but the gray tops are standard throughout the country. Everybody uses.
Correct.
Okay. And the testing is standardized throughout the country. It's done the same way here as it is in California.
No, not always. Here we were using a dual column instrument. The modern, more reliable instrument would be a GCMS, as in mass spectrometry.
What states employ GCMS?
Several counties in California. GCMS for alcohol is not as common as it is for drugs. I'm not sure offhand.
Are you familiar with the Michigan police guidelines for how many times the blood is supposed to be inverted in the tubes?
No.
What is, you stated that S does not occur naturally in the blood. What do you base that opinion on?
Well, the laboratory runs known samples of various compounds, including acetone, because they're running known byproducts of fermentation, because you need to run them to see if they're present. So if you're running them to see if they're present, you're doing that so that you can figure out if there's fermentation or not.
How often does fermentation occur?
It would depend drastically on conditions and, the temperature, the delay between between the draw and testing.
When does fermentation stop?
Usually when the microbes run out of substrates that they can convert to alcohol.
So you tested the blood here to confirm that it was higher than 0.18, that it kept fermenting, correct?
No.
You stated that you don't believe at the time of the draw her blood alcohol was 0.18. What do you believe it was?
We can't determine the amount of error associated with fermentation based on the byproducts.
Was her blood alcohol higher than 0.18?
Not with fermentation, no. It would have to be lower at the time of the draw.
Do you want me to take a break, Judge?
No,
Sorry.
go ahead.
Is it, so it's your opinion that her blood alcohol level was lower at the time of the draw?
I'm going to check. He said he doesn't know because fermentation takes place. It's speculative. So what was her blood alcohol level? First of all, it's presumed something that, it makes no sense. You can't speculate if there's fermentation. He said it can occur with no alcohol in your system. It's hardware.
Judge, he's testified that he believes fermentation occurred. I'm trying to establish whether or not he believes the result is accurate. Was it 0.18 at the time of the draw, or was it lower at the point of the draw?
I think it's a fair question. I'll allow the question. Objection.
It would be significantly higher at the time the blood was collected. I'm sorry, at the time of the testing than when the blood was collected.
So her blood alcohol increased from the time of the draw to the time of the testing.
That's what fermentation does.
And what causes this rising alcohol to occur again?
The microbes, bacteria, and fungi. Often it is a microbe called Candida albicans, which the preservative does not slow down. And the thing that's called a preservative can actually speed up fermentation with Candida albicans.
Does the Michigan State Police procedure require refrigeration of collected samples?
I saw something about refrigeration. I don't recall it well enough to give an answer.
Do you know how much the defendant had to drink on that day?
I read something.
I didn't hear the question.
Repeat the question.
Do you know how much the defendant had to drink on the day in question?
No, I wasn't there. I read something in the report. It might have been 1 or 2 glasses of wine.
But you weren't present?
No.
So you don't have any idea if she had 1 glass of wine or 40 glasses of wine, correct?
Well, with the testing, I wouldn't say 40, but I don't know how much.
So with the testing, how much do you think she had then?
Objection, Your Honor, because the testing fermentation took place. You can't guess and be speculative. What do you think she had? What do you think I had?
Judge, he said with the testing, I wouldn't assume 40, so maybe he's got an answer to this.
He's also an expert witness who can give his opinion. If he can't base his opinion on what's been presented, then he'll say something.
Okay. 40 drinks would be, even with hard alcohol, I doubt somebody's belly could hold that much.
I understand. How much do you believe she had to drink based on the testing results that you've looked at?
I cannot tell because of the unreliability of the testing.
The state of Michigan test blood like this every day, multiple samples a day. It's your opinion that some percentage of those ferment every day.
I don't know what percentage. I can say in this case it fermented.
And that's because acetone doesn't occur naturally in the human body.
Neither does isopropanol.
1 second, please. We have no further questions.
Redirect.
The whole purpose of the testing in toxicology in the blood testing is for accuracy, correct?
Correct. Forensic testing, you want to get it as accurate as possible.
And from all your studies and all the cases you've worked on and all the cases you've testified in, are samples of blood supposed to be refrigerated?
They're supposed to immediately be put in a refrigerator freezer per the national standards and tested as soon as possible.
And the national standards go with the uniform testing kit, right? That applies. The uniform testing kit that that company has a monopoly on.
Yes, the tubes.
And because somebody violates that or a county violates that, that doesn't make it right. Is that correct? There's national standards.
Correct.
And how many times, and does that also then apply to how many times a tube should be inverted? You had said how many times?
8 to 11
That's to make sure that all that powder that's stuck on the bottom is dissolved.
is mixed in with the sample.
And is it the national standards to do it this 8 or more times?
I don't know if the national standard states the amount of times or to follow the manufacturer guidelines. I don't remember that specifically.
And what's the manufacturer guidelines?
The 8 to 11 times.
And do it less than that, you may not have accurate results.
Yes, per the manufacturer.
And that's because fermentation could take place.
Yes, and it can take place without, without the preservative, with the preservative.
Thank you. I don't have any further questions.
Recross.
May I first witness?
Yes.
I'm going to show you what is the FSD 093. This is the Michigan State Police instruction form for drawing blood.
Your Honor, may I take a look at what you're showing on the
Sure.
Thank you. Excuse me. Your Honor, I'll object because this has never been, I've never even seen something like this where I found it, and nobody's testified to it. I don't know if it's old, new, what this piece of paper is. So,
Judge, we've used it in the trial already.
Yes, and there's been testimony regarding it already. I was going to ask you if it's an exhibit. Because,
We have not admitted it as exhibit, but perhaps we will.
yeah. All right. The objection's overruled. It's clearly been testified.
Excuse me. Can you take a look at that, please? Tell me if you recognize that document.
You want me to read the back of it?
I just want you to take a look at it and tell me if you recognize it. Have you seen it before?
No.
and Your Honor, also objection because he's already had his opportunity to ask him questions and cross. Now he's going into another tangent.
You were asking about the standards. I think it's a legitimate question. The objection's overruled.
In the state of Michigan, we talked about actually, hold on to that for 1 second.
Okay.
if you would. The Michigan State Police has policies and procedures associated with blood draws in the state of Michigan, but you're not familiar with those policies and procedures, correct?
This is the Michigan
That
State
is
Police.
not it. This is a question aside from that document.
Oh, okay.
Are you familiar with the Michigan State policies and procedures that govern drawing and testing of blood?
Not in particular, but they're pretty standardized.
Okay. The state of Michigan, through the Michigan State Police, creates blood draw kits. We've used it in court already. This is the kit. And every kit is that form. Can you tell me what number 3 on the back of that form says, please?
Slowly invert blood collection tubes enough times to distribute the sodium fluoride, potassium oxalate preservative.
Enough times? Is that what it says, or does it say 8 to 11 times?
Says enough times.
Okay. It's your opinion that the Michigan State Police policy and procedure is wrong.
No, I'm saying the manufacturer tells you what enough times is.
Judge, people are going to move for admission of People's Proposed Exhibit 39. That is the FSD 093 form that has been referenced a number of times throughout the case.
Response.
Sure, I'll stipulate to that. I don't agree that that's proper, but I'll stipulate to that exhibit, but it doesn't meet the national standards, according to my.
People's 39 is admitted.
And how much were you paid to testify today?
I was paid a retainer of $5,000, and then I had expenses.
And what were those?
Approximately 1,200 total.
So all told, about $6,200?
No, I didn't get anything other than the $5,000 retainer.
No further questions.
Redirect.
That piece of paper that shows you, is that from the national, or excuse me, is that from the manufacturer of, is that from the manufacturer of the biological arrowhead forensics kit?
You know, those kits are made using the Becton Dickinson vial, and the Becton Dickinson vial manufacturer guidelines tell you how much is enough to mix it.
Okay, do they just say, mix it enough, use your own, judgment, or do they say 8 to 11?
The manufacturer says 8 to 11 is required to be enough.
Of inverting each test tube?
Correct.
Okay, and you're sworn to tell testimony today, you're sworn to tell the truth. Is that the absolute truth?
Yes, absolutely.
I don't have any other questions.
Any follow-up on this?
No, no.
May this witness be excused.
Yes, Your Honor.
Yes, Judge.
All right, thank you. You may step down. Okay, thank you. Next witness, Mr. Clovis.
Your Honor, may we approach this for a moment? Appreciate it. Thank you.
Minutes B is admitted.
That's a receipt from Verna.
Yeah.
Well, good jury. Thank you.
This matter before the court shall be.
If you would state your name and spell your last name again, please.
Yes, I am Tabitha Faust, Faust.
Thank you, Judge. Ms. Faust, thank you for being here again. You were, because of court rules allowing the same, you were able to be in the courtroom to hear defense's expert testimony. Is that right?
That is correct.
When you received the blood sample in this case, Ms. Faust, what was its condition?
The condition I would consider to be normal. As part of our checking process, we look at the samples before we test them to make sure that there isn't a large clotting issue, that everything is mixed in, all the information on it matches our system. It is part of our normal check when we test.
So was there any clotting of the blood in this case?
There was not an excessive amount of clotting that I had noted, or I would have put a note in the case record.
Okay. And what is that indicative of?
So to me, that's indicative that the sample was properly preserved because there is an anticoagulant that is in those tubes. If it had not been mixed properly, then I would have expected the blood to have clotted.
In your role as a forensic toxicologist, do you have any involvement or any opinion regarding inversion of the tubes to distribute the preservative?
I don't know if I have a lot of opinion on it. I know that as part of our practice, we do actually rock the samples before we test them as well to make sure we get a well-mixed sample for testing.
Does the lab have a policy on accepting blood samples that haven't been refrigerated?
Our policy is that we accept any samples that have been delivered to us. Our official ASB standards states that it is acceptable to send samples unrefrigerated as long as they are received within a reasonable amount of time.
And do you have a qualification for what's a reasonable amount of time?
I do not.
Okay. How long between collection and testing was the blood in this case?
In this case, I pipetted this sample less than 48 hours after it was collected.
Okay. In your opinion, would that be a reasonable time?
That is extremely fast for blood alcohol sampling.
Defense's experts spent a good time speaking about acetone and isopropanol.
Yes.
Did you locate any isopropanol in this sample?
No, I did not. The instrument picked up, there was a peak shape in the window, but it didn't even integrate it because it was so low, it couldn't really differentiate it from background noise.
If you could explain peak shape in the window that the instrument didn't really integrate.
So whenever you run a sample on a GC, there will be it's not a completely flat baseline. There are peaks, so like mountain shaped, and in the isopropanol window, so that time frame, there was a small blip that kind of looked peak shaped, but it was so small that it was considered insignificant by the instrument and myself as the reviewer of the data.
And I think you described the acetone that occurred in the sample as insignificant as well. Is that right?
Yes, it was slightly larger in that the peak actually met some of the quality criteria for what we call a peak, but it was still extremely small, which is why it was not reportable, and it was only integrated on 3 of the 4 results.
And the isopropanol was even smaller than that.
Yes, it was completely insignificant.
Do you have any knowledge, or have you read any literature in regards to acetone naturally occurring in the body?
Yes, I have.
And what is that?
So acetone can naturally occur in the body for many reasons. One, like I mentioned yesterday, is in diabetics. If you, especially uncontrolled diabetes, you will have ketones in your system, which is one of them is acetone, and you can go into diabetic ketoacidosis, which is a high level of acetone. The fad diet, the keto diet, tries to get you into that ketosis state, and that is also will increase the amount of acetone in your system naturally. High levels of stress, pregnancy, and even a binge drinking episode can cause low levels of acetone in your blood naturally.
This level of acetone, would that be in line with the studies you've reviewed?
Yes, it would.
You heard defense's expert testify to a study that he was familiar with where a blood sample that started out with no alcohol was allowed to ferment and reached 0.10 within 24 hours. Did you hear that testimony?
Yes, I did.
Did you hear him cite the name of that study?
It sounded like it was by the author of Bloom, but I'm not familiar with that study.
Okay. You've never heard of that in your trainings or in your profession?
Not that particular study. I have other studies on fermentation I've read, but not that particular one.
How many studies on fermentation have you read?
A great number of them. One in particular that we refer to a lot, they were attempting to create fermentation in a tube, and the highest amount of ethanol they were able to produce was 0.071, but that was after 5 days of not being refrigerated.
What could cause fermentation in a tube?
So fermentation is caused by different kinds of microbes can cause it. But that is why the manufacturer of our tubes puts in that preservative to destroy any microbes to prevent fermentation.
Okay. If you received a tube that had experienced fermentation, would it be different from a typical tube?
So most fermentation processes produce a gas. And so when I go to open, to pipette the sample, I have to take the stopper off the tube. And that buildup of gases, I would be able to hear it and sometimes even see it, because the blood could, in rare cases, actually shoot out of the tube because it's under pressure from the fermentation process. And none of that occurred in this case.
So in your training and experience, is there anything to suggest that this blood had suffered from the fermentation process?
No.
Is there anything in your training and experience to suggest that this blood was not properly preserved?
No.
Is there anything in your training and experience to suggest that this blood was not properly stored and transported before it arrived at the lab?
No.
Just one second. No further questions.
Cross. Ma'am, you said that you did not see any large clotting in the tube or tubes?
Correct. I have seen improperly stored tubes before where the entire sample has congealed, isn't it? It was like a gel-like substance almost, and that was because it was improperly stored.
When you say improperly stored, like how?
I don't remember the particulars of that case, but I believe it was left for a very long period of time in a very hot squat car.
Could that also occur if you don't shake it enough?
I would assume so because the anticoagulant would not have been distributed within the sample.
And it's very important that the anticoagulant gets distributed very well. Am I correct to preserve it?
Both that and the preservative, yes.
And you stated earlier, and it sort of stuck out in me. You stated not any excess amount of clotting. So you said I interpret that as there's clotting, but it's not in excess. That's what you said, not any excess amount of clotting. So was there some clotting at all in it?
I didn't know any clotting in this sample.
What did you mean by not any excess amount of clotting?
If the anticoagulant hadn't been mixed in, then I would expect a large amount of clotting in the sample as evidence of that. And I did not see that. I did not know any major clotting or even minimal clotting that I noticed in this sample.
So earlier when you testified with the prosecutor, you didn't say there was no clotting. You said not any excess amount of clotting. So it wasn't any serious clotting in your opinion, correct?
Correct.
Okay. And did you look at it all under a microscope or anything that type of regarding clotting and things like that?
No.
And you work for the state of Michigan, correct?
Correct.
Okay. In the toxicology department, correct?
The toxicology unit of the Michigan State Police.
Okay. And you're supposed to do your job as best as you can, correct?
Correct.
And acetone, you said it's okay if you have some acetone in your blood?
Yes, a small amount of acetone is perfectly acceptable and normal.
So acetone is used as a solvent, correct?
Pure acetone is, yes.
And it's okay to have a little bit of that in your system, you're saying?
Yes.
And you got studies with you today that says you can have some acetone in your blood.
I have a study with me today that says acetone is naturally occurring in the body, yes.
It naturally occurs. And it says what level that you can just have it and you're healthy.
It does not, I don't believe it quotes a certain level, but the level that I found in this sample was extremely low.
Okay. And that can occur also if somebody's pregnant, right?
As I stated before, pregnant, high levels of stress, diabetic episodes, any of that thing can raise the amount of acetone in your blood.
Did you know my client was not pregnant on April 20th, 24?
I do not know your client.
Would you agree that fermentation is not good in a blood sample, no matter how much, to get a true and accurate reading? Would you agree with that?
Yes.
Would you agree that the blood testing sample, if taken right from somebody in the hospital and tested in the hospital, would be much more accurate than trying to do these shakes and have them, several days later be tested?
I can't testify to that because I've never worked at a hospital, so I don't know their testing policies and procedures.
Okay, that's fair. Would you agree that not having any refrigeration whatsoever on a blood testing sample and then giving it to you days later could cause some fermentation?
Fermentation is a complicated process that needs more than just not being refrigerated. You have to have the exact right microbes, you have to have enough glucose in the system, and you have to have a low enough blood alcohol level that the microbes won't be killed off by the ethanol by itself.
Were you able to test for that before you tested to make sure all those things didn't exist?
I don't understand your question.
You said, you just repeated or you just stated all these different things that have to be met regarding fermentation, correct?
Correct.
Okay. Are you able to test for that to see, is this a fermented sample or not before I test it?
No.
Or you just test it and you hope it's not fermented?
As I said before, the tubes have a preservative. There's evidence of fermentation.
I'd like for you to stick.
Hang on a second.
Well, I want her to stick
No,
with the
no, do
answer.
not interrupt her.
Okay.
Evidence, physical evidence of fermentation, like the gas buildup, like I spoke of earlier, would exist. That is something we are trained to look for to prevent fermentation. But did I test for microbes? No, I did not.
Okay. That's what my question was, and I apologize, Judge, that I interrupted. And did you, when you opened the tube, did you have any type of instrument that would measure any gases that are emitted as soon as you open it?
No, I do not.
And I may hand you something. Ma'am, and I just talked to the prosecutor, and I believe he doesn't object to this communication log report, which would be defendant's exhibit C. And I'm going to show you it and see if you recognize it. I believe it may have been printed from your workings. Please take your time. And I understand it's not the full report of all the testing that was done, but I'd look for you to look at this proposed exhibit or exhibit that shows the different graphs that we talked about or you talked about. Does that look accurate?
Yes, these look like the chromatograms.
Thank you. And ma'am, do you have a copy of that with you? Or is it easier for you to just look at mine?
Today it would be easier to look at yours.
All right, thank you for
Oh,
being.
no, I found them. Never mind.
Great, thank you. And do you see, it says upper right-hand corner, GC 19-1. It's really the second page after this page.
Yes.
All right, thank you. And it shows the acetone figure under the FID1. What's FID1 mean?
So that is our flame ion detector number 1.
Okay, and then FID2, I presume is your second one you have.
Yes, that is the
All
second
right,
one.
I'm learning. All right, thanks. And then you have a graph on the third page, second page, that shows acetone number 2 in the FID2. Is that correct?
Yes.
All right, thank you. And it shows that peak going up, correct?
Yes, the integrated acetone peak.
Thank you. And then you have GC 19-2, that page. I'm going to ask you to flip over that. And then we have on the upper right-hand corner, it says Allergen Technologies. And it says page 2 of 2 at the bottom. Do you see that one?
Yes.
All right, thank you. And you see acetone and a graph going up. Is that correct?
Yes, under FID1.
Okay. And then under number 2, you show a graph going up. Is that correct?
Correct, an integrated peak.
Okay, thank you. And that's all acetone, right?
Yes.
Okay. Then formally, I would ask to admit defendant's exhibit C.
People don't object as long as we publish to the jury. That's only a partial part of the report.
Defendant C is
what the people don't object.
It's marked, Your Honor, and I also put that on the record. It just needs a staple. All right, thanks. I don't have any other questions of this witness. Thank you, ma'am.
Any redirect?
Just one last question. This is just a refresher from yesterday. What was the acetone level in this sample again?
So the acetone level in 3 of the 4 detectors was 0.002.
What per?
It'd be grams per deciliter.
Okay. And in your training and experience, is that indicative of anything as it pertains to the alcohol test? The ethanol test, I should say.
No, for us, that is so small that we don't even report it.
Nothing further, Judge.
Your Honor, just one more question. Ma'am?
Yeah.
Thank you. And you decide that it's so small that you don't report it, correct?
So we have a calibration curve, and that is how we accurately.
If I may, it's a yes or no answer.
I don't think it's a yes or no answer, so let her answer the question.
So we have a calibration curve for any compound that we can quantify and report. And our acetone calibration curve starts at a 0.01. So that is the level at which we start reporting it.
And are you aware of hospitals that they start at different levels? Are you aware? Yes or no?
Hospitals test for different reasons, so I assume their levels would be different than forensic testing.
Thank you. No other questions.
Anything else?
No, thank you.
May this witness case excused.
She may.
Thank you very much. Any other rebuttal witnesses?
Yes, Judge.
People call Anthony Fowler.
You solemnly swear or affirm that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth.
Yes.
State your name and spell your last name, please.
My name is Anthony Kathawa, Kathawa.
Thank you, Judge. Good morning, Mr. Gonzalez.
Good morning.
Are you employed?
Yes, I am.
How so?
I work at Fermi 3 Party Store, and we're in Newport, Michigan.
In Newport, Michigan?
Yes, sir.
And you said party store, you sell alcoholic beverages?
Yes, we do.
So, okay. Were you employed in that role on April 20th of 2024?
Yes, I was.
And were you working that day?
Yes, I was.
What time did you go into work?
I'd like to have a sidebar, please. It's very important.
So I'm just going to start over. You work at Fermi 3?
Yes, I do.
You were working there on April 20th?
Yes, I was.
Okay. What time did you get to work on that day?
Just before 9 o'clock, before we open.
What time do you open?
We open at 9 o'clock.
Okay. And did you make a sale on the day that brings you here today?
Yes, I did.
Do you remember what that was?
Yes, I do.
Do you remember who you sold it to?
Yes, I do.
Okay. And do you keep records of the sales at your store?
We have a POS system. Our receipts are saved in the POS system.
Okay. POS, for those of us that aren't in the industry, is that point of sale?
Yes, it is.
All right. That's your cash register, right?
It is our cash register.
Okay. And so are you able to sort of replicate receipts from any transaction?
By replicate, you mean reprint?
Sure.
Yes, we can
Okay.
reprint a receipt that has gone through already.
Do you have access to that system?
We do have access to it, yes.
Okay. And you can go in and find a sale from April 20th of 2024 and reprint the receipt?
We should be able to.
Okay. Do you know if you did that on that with regard to that sale?
Yes, I did.
Okay. I'm going to show you what is marked as People's Proposed Exhibit 36.
I don't object, Your Honor, if he's going to be handed.
All right, people, 36 is admitted.
Thank you, Judge. Can you put that on the screen, please? Mr. Gonzalez, do you recognize that document?
Yes, I do.
Okay. And can you tell me what that is?
It is a receipt of the transaction made that day.
Can you read the date, please?
Yep. Yeah. 04/20/2024, April 4th, 2024.
And what time was this transaction made?
9:01.
So 1 minute after you opened?
Yes, sir.
All right. And what is on that receipt?
It is a 4-pack of Sutter Home Pinot Grigio wine and Silver Rain Cabernet, a bottle of wine.
When you say a 4-pack of Pinot Grigio, just a few questions about that. What is Pinot Grigio? I mean, I know it's a wine. Is it a red wine, a white wine?
It is I would say a white wine. It's clear in color.
Clear in color. Okay.
Yes, sir.
A 4-pack is what size approximately would those bottles be?
Honestly, so it's 187 ml. It's a really small bottle of wine. It's like
Sort of like what you would get on an airplane.
Yeah, you could say that.
Okay. It's equivalent to about 1 glass of wine each.
I am actually not sure about that.
That's fair. And then the bottle of Cabernet, that was a more traditional size bottle?
Yes, it was a regular standard bottle. I think it's 750 ml.
And is Cabernet a red wine or a white wine?
It is a red wine.
Thank you. I don't have any further questions for this witness, Judge.
Cross.
Yes, Your Honor. Oh, correct. Sorry. Right.
When you open at 9 o'clock, you have people every day come in and buy things.
Yes,
It's not unusual.
it's not.
And it is, are you like, I've driven by your place. Is it like a neighborhood type place?
It is.
You get to know everybody?
Depends. Some
Or
people are in and
you
out.
get to know, you get out of town or sometimes.
Yes, we do.
And that's a truthful receipt, right? Because that's
Yes,
what
it
took
is.
place.
It is a truthful
We
receipt.
don't doubt it. Okay. And do you know those bottles, are they like little 4-pack with bottles about that big?
Yeah, about that size.
Okay, they're like around that round.
Yes, they are.
All right. And people buy those sometimes? That's why
Yes.
you carry them?
Of course.
Okay. And do you remember my client coming in that day?
Yes, I do.
Okay. Did she seem like she was intoxicated at 9 in the morning?
No, she showed no signs of that intoxication.
Thank you very much. And if she did, you wouldn't be selling alcohol.
Exactly.
right?
We
Okay.
refuse. We have the right to refuse to sell to anybody that's
And you
intoxicated.
might even call the police too. if
We
they
could
don't
call the
think they
police.
harm themselves. Okay. And then there was a bottle of, did you say?
It was a bottle of wine, Silver Rain Cabernet.
Okay. All right. And people bought things from, it was the lawful time to be able to buy anything for your house, right?
Yes, sir.
Okay. And she didn't sit there and open the bottle and start drinking in your
She did
place,
not,
right?
and we do not condone that. Allow that.
Right. I don't like it. And she didn't sit there and go outside and start drinking a bottle of wine, did she?
I didn't go outside, so
Okay, do you have
can't
video?
tell you.
you have video outside?
We didn't have cameras at the time.
Okay, all right. And so, do you know where she went from there at all? No?
I don't.
Okay. And do you know whenever in the future that may have been consumed, whether it's that day, the next day?
I was not with
any
her.
day?
Nope, no clue at all.
That would, you would be speculating, right? You
Yes.
don't know. Okay.
All I know is that she purchased it for me, and what she did with it, I have,
And
No clue.
she presented herself very presentable and things like that.
she was,
Okay, I don't have any other questions, John.
Any redirect?
No, Your Honor.
All right, thank you. May this witness speak, excuse me.
Yes, sir.
thank you, buddy. Appreciate it. Thank you, Judge.
Any other rebuttal witnesses? Yes, Judge.
Okay, I'll Deputy Howard Pratt-Moore. Afternoon, Deputy. Morning.
Morning.
It's been a long week. What do you do for a living, Deputy?
I'm a deputy sheriff with the Monroe County Sheriff's Office.
How long have you held that position?
Approximately 8 years on road patrol.
And what's your current assignment?
I'm assigned to traffic services.
And what does traffic services do?
So traffic services is a division within the sheriff's office. I handle crashes on the road, fatals, VIN inspections, just any traffic complaints if somebody were to call into dispatch and was having a traffic issue.
In your role with traffic services, did you play a role in this investigation?
Yes, I did.
What was your role?
So I responded to the scene the day that it happened on April 20th. From there, my supervisor advised to respond to Verna's and take part of that investigation.
And you did so?
Yes.
Did you do anything in regards to the defendant's 2017 Ford Edge?
Yes, I did.
What did you do in regards to that?
So on April 22nd, around 12:30, Deputy Burkhart and I responded to Jim's Towing to conduct a vehicle inspection of the 2017 Ford Edge. While there, Deputy Burkhart needed the EDR, the black box, out of the vehicle. Jim's Towing employee, Forrest Peck, was removing the EDR from the vehicle, and he made a discovery from the inside the vehicle.
And what did he, I'm going to show you what you brought for us in just a brown paper bag, but there's something in an evidence envelope inside.
Yes.
So, any of this case in chief should have been brought in case in chief. I have no idea that it would be rebuttal, that all of a sudden it's an afterthought to find something. It should be a case in chief.
Same response to the sidebar, Judge, if you want me to make a record of it. Defense's case is that defendant only had one glass of wine that day, and through some sort of chemical process that turned into a 0.18 alcohol level by the time of the crash or the draw. This is all to specifically rebut that proposition.
All right. Well, certainly the other testimony was, I don't know what this is yet. So I
Fair
guess we'll see.
So, Deputy, you were present when Forrest Peck, the tow truck driver, was removing the EDR.
Yes. While he was doing so, he located a 187 milliliter bottle of Sutter Home Chardonnay, which was turned over to me, photographed, and was placed into evidence here.
And that was located in defendant's vehicle?
Yes, in the center console.
Okay. People would move to admit the bottle as People's Exhibit 40.
Response?
I don't have any objections to this testimony concerning it.
People's 40 is admitted.
No further questions.
Cross.
Can I take a look at that, please?
I'll have you to,
If you're done.
I'm done with it. Thank you.
Sorry, I got the line to step.
No, I did want to look at it. Thank you. Officer, do you know when that was drank?
I do not.
Okay. Do you know of people that do returnables and they have a bag of returnables and things like that? And returnables, but also recycling too. Do you know, have you ever heard of people doing that?
Yes, of people recycling plastic, yes.
All right. Do you know if my client ever was like always recycling everything?
I do
Sort of
not.
an earth person?
I do not know.
And do you know where that plastic, is it a plastic bottle?
I
Whatever
don't
it is,
recall. I
it is.
believe so. Yes, I know it's a bottle
Do you know where that came from?
from the center console of the vehicle.
Okay. And have you ever seen any videos or photos of my client ever sitting in a car drinking?
I have not, no.
All right. Do you ever take any recycling items to be recycled, such as bottles or cans or plastics?
Me personally, I
That's what the deputy
How is
does.
it relevant?
I'll withdraw, Judge.
All right.
Have you ever pulled anybody, have you been a patrol officer?
Yes, for 8 years.
Okay. And have you ever pulled anybody over, investigated, and see they have returnables inside their vehicle?
I mean, I'm sure.
Objection, relevance.
Well, I'm laying foundation if it's an unusual thing to see, returnables.
I'll take the answer.
Thank you. Have you seen that before, ever?
I mean, yes, I have recyclable. I have bottles in my patrol car right now. Yes.
Okay, all right. And that doesn't mean that they drink that wine right then and there or prior to, correct?
I don't have that answer.
Right, all right, okay. It would be all speculation, right? You'd be guessing.
Yes, I would be. Yes.
All right, thank you. I don't have any other questions.
Read right.
No, thank you.
May this witness be excused.
Yes, you may.
Thank you.
Thank you, Judge.
Next witness.
Thank you, Judge. At this time, people call Detective Kenneth Dodds.
Detective, if you would state your name and spell your last name, please.
Yep, Detective Kenneth Dodds, Dodds.
Good morning, Detective Dodds. Are you currently employed?
I am
Where are you employed?
with the Monroe County Sheriff's Office.
And what is your role there?
I am currently a detective with the Monroe County Sheriff's Office.
And what training or experience do you have to have prior to being delineated as a detective with the Monroe County Sheriff's Department?
So I attended the Oakland Police Academy and graduated there in 2017. Over the course of the past 7 years, I've attended multiple investigative schools, some being basic detective school and evidence technician school.
And so I think you just answered my question, but approximately how long have you been a detective?
A detective approximately 2 years,
And how long have you been employed by the Monroe County Sheriff's Department?
7 years.
And prior to that, did you have any experience in law enforcement?
No, I did not know.
So the entirety of your experience is with the Monroe County Sheriff's Department.
Yes.
Was there something as a result of your employment, were you involved in an investigation of involving the Swan Boat Club in April of 2024?
I was, yes.
What was your involvement with that case?
A couple days after the incident happened, I helped execute a search warrant on the defendant's house.
Do you recall the exact date by any chance?
I believe it was 4/22 of 2024.
So that would be April 22nd?
Correct.
Okay, thank you. Detective, as a result of that investigation, or rather, what, if anything, was the Detective Bureau hoping to find or anticipating that they might find as a result of the search warrant being executed?
So through the course of our investigation, we learned that the defendant purchased alcohol prior to the crash happening. So part of the search warrant was to locate any evidence related to that.
And Detective, do you happen to recall what she purchased, if you can recall at all?
I don't recall exactly.
Okay. As a result of the execution of the search warrant, did you find anything relevant to that inquiry?
We did. We located multiple small wine bottles in the kitchen trash can. They were all empty. I believe they were Sutter Home brand. And we also located a couple Fireball brand empty bottles as well.
Detective, you indicated that you kind of used your fingers to implicate. Do you recall, were they large bottles of wine? Were they small bottles of wine?
They were small bottles of wine.
Do you know how much is found within the small bottle of wine of Sutter Home that you just mentioned?
They were empty at the time we located them.
Okay, sorry, that was not a very clear question. When you say small bottles of wine, do you recall exactly how much that particular bottle holds?
I don't recall exactly how much.
Okay, Judge, can I see Exhibit 40, please? May I approach? Thank you. Detective, I'm going to show you what has been marked as People's Exhibit 40. May I approach the witness, Your Honor?
Yes.
Thank you. Detective, can you take a look at this bottle and I suppose familiarize yourself with it and then look up at me when you were done? Okay. Based off of your recollection from executing the warrant at the scene, is this similar to the bottles that you found?
Yes, this is very similar.
Okay. And can you just look on the bottle and articulate for the record how much is found within that bottle?
Looks like 187 milliliters.
Thank you. May I approach, Judge?
Yes.
Thank you. I'll take that back from you, Detective.
Thank you.
Detective, do you recall what type of wine was found, I suppose, and when I say type of wine, Chardonnay or any other type of wine was found in those bottles, or I suppose was at one point in those bottles?
I don't recall exactly what kind of wine it was.
Okay. Are you familiar with types of wine?
Vaguely.
Okay. Do you? That's okay. Do you withdraw your objection? Okay, thank you very much. Yep. And Detective, you indicated there were several empty bottles of Fireball whiskey as well?
Yes.
Okay. Detective, did you find any full bottles of Sutter Home of the 187 milliliters that you just indicated?
No, we found no full bottles.
Did you find any full bottles of wine within the home during the execution of your search warrant that you can recall?
Not that I can recall, no.
Thank you, Detective. That's all I have for you.
Thank you.
Now, this tragic accident happened on April 20th of 24, correct?
Yes, sir.
And you executed a search warrant at the residence of my client and her husband on what day?
The 22nd.
So 2 days later, correct?
Yes.
Okay. And my client was not at her residence during those 2 days. Do you agree with that?
She was not there at the time of the search warrant.
And was she there a day before, or was she somewhere else?
I do not know that, sir.
You don't know if she was arrested and in jail?
Oh, I believe she was in jail at that time.
Okay, so that means she wasn't at her residence, right? She couldn't be at a residence and in jail at the same time.
Correct.
Okay. And do you know when those bottles, those 4 little bottles, when those were drank?
No, we do not know when they were drank.
And do you know who was residing at my client's residence when you showed up with a search warrant?
Her husband was there at the time.
Do you have any reason to believe that her husband was not residing there every day for a long time prior?
No.
All right. And do you know what he drank when he was at the house those 2 days?
No, I do not know what he drank.
All right. So you're not in front of this jury in court. You're not alleging that my client absolutely drank these 4 bottles that were purchased 2 days before, are you?
I can't say who drank those bottles, sir.
All right. I appreciate your honesty. Thank you. Now, the bottle that was found in the car, did you hear about that? That was some exhibit that was just showing you. There's like a plastic bottle. It
I'm
was showing
aware. Yeah, I'm aware of the
Right.
exhibit.
Did you ever go look at the lot number on that and measure it with the lot number from the party store?
No, we did not.
I don't really know what he's referring to regarding the lot number and also.
Lot. LOT.
Yes, I still don't know what he's referring to regarding the lot number. And I don't believe that there's going to be testimony from Detective Dodds regarding the lot numbers.
All right, I'll withdraw that. That's fair.
Okay.
Now, because there was no cold bottles of these wines, does that mean when you execute a search warrant, does that mean that my client's husband could have never drank those for 2 days?
So I'm going to object to speculation. I don't really know, first of all, what the relevance of this is, but secondarily, I think he stated that most of the bottles that he found were empty, if not all bottles.
I totally agree as to the relevancy of this. I'll withdraw it.
Any redirect?
No, Judge,
Any
thank you.
to be excused?
He may, Judge, thank you.
Thank you. You may.
Thank you, Judge.
Next, by the way.
Judge McCall, Detective Sergeant Jeffrey Hooper.
If you would state your name and spell your last name, please, Detective.
Jeff Hooper, Hooper.
Thank you, Judge. Sergeant, you testified previously that you executed a search warrant on defendant's home. Is that correct?
Yes,
And when was that done?
that would have been Monday. I believe it was the 22nd
And
of
you-
April.
Sorry, you testified that you found some cameras and a DVR recording system.
Yes,
Did you find any cameras inside the home?
yes,
And how many cameras were there?
one
Where was it located?
in the kitchen area.
In the kitchen area? Were there any were you able to locate any recordings from April 20th of 2024
Yes,
in the kitchen area camera?
yes,
And did you have a chance to review those videos?
yes.
And did you find the timestamp to be accurate on those or similar problem as the other ones?
Similar with the other one. Again, if it was an hour behind. So if it said 3 o'clock on the timestamp, it would be 2 o'clock.
Did you make a copy of these videos?
Yes,
And you viewed them, correct?
yes,
Okay. You reviewed what's purported with people's proposed exhibit 38A through 38F.
yes,
And are these all of the recordings from inside the home?
no,
Just pertinent to the case that you?
correct.
Judge, I'm going to move to admit people's 38A through 38F.
You gonna play it?
I'll move to proffer next, Judge.
All right.
All
Let's do
right,
that.
can we play 38A, please? Yeah. Detective, can you, for me, tell me what the date and time is on this?
So the original date and time is 4/20 of 2024 at 8:24 and 47 seconds in the morning.
And so that would actually be what time?
9:24 and 47 seconds
AM.
a.m.
Okay, please play the video. Please play 38B. Or I should bring it up. Detective, what is the timestamp on that?
9:24 and 38 seconds AM.
What would be the accurate time then?
10:24 and 38 seconds AM.
Please play the exhibit. Please pull up 38C. Detective, what's the timestamp and date on this one?
9:45 and 12 seconds AM.
Also from April 20th?
Yes.
So what is the accurate time then?
10:45 and 12 seconds AM on the 20th.
Please pull up 38D. Detective, what is the date timestamp on this one?
April 20th, 2024, 11:35 and 1 second AM.
And what is the actual time, accurate time?
12:35 and 1 second, and that would be PM.
Please play the video.
Your Honor, for the record, this is 38B.
That's correct.
Okay, thank you.
Please pull up 38. Detective, what is the date timestamp on this one?
April 20th, 2024, 1:10 and 38 seconds PM.
It says 13:10, but that is the translation's 1:10 PM.
I'm sorry, yes, that's military time.
Sure.
So
What is the accurate time?
that would be 14:10 and 38 seconds or 2:10 and 38 seconds PM.
Thank you.
Your Honor, for the record, this is 38E.
He is in here.
Thank you.
Please pull up 38. Detective, what is the date and timestamp on this?
April 20th, 2024, 13:31 and 50 seconds or 1:31 and 50 seconds PM.
And what is the more accurate time based on timestamp and accuracy?
It would be 14:31 and 50 seconds or 2:31 and 50 seconds PM.
Approximately 30 minutes before the crash.
Correct.
Please play the video. Judge, people again move to admit exhibits 38A through 38F as in Frank.
Response. Your Honor, we have no objection, just for the record, prior motion was filed prior concerning this, but no objection.
People's 38A through F, there are.
I have no further questions for this witness, Judge.
Cross?
Officer, did you, were you ever inside my client's home prior to the date you executed the warrant?
No,
And when you obtained this videotape, you obtained the contents of the videotape, correct? Or the video machine or recording machine?
yes,
Okay, with this search warrant, right?
yes,
Okay. Did my client participate in you going through, well, you had a chance to go through and look at hours of videotape, correct?
correct,
And he didn't stop you at all from taking the videotape, you asked for it, and he showed you where it was, and he gave it to you, correct? My client's husband.
correct.
Okay. And you didn't have him come to your office and go through the videotape from start to finish to confirm that that's the videotape, no editing, no nothing, that it's the full videotape. Did you ever have him come do that?
He did not come to my office, no.
But you never went through the entire videotape with him prior to you starting to edit and show certain fragments today, correct? He didn't participate in editing this, correct?
It's not edited. It's just the videos were taken off of the DVR.
Okay. If the DVR has 6 hours of recording and you take 2 or 3 spots, segments, that would be editing, right? Because it's like taking a police report and putting black certain parts.
I can't say one way or another. I don't believe
Is that the
so.
full videotape?
Is that the full contents of,
Of
Hey,
4
hang on a
hours?
second, ask him a question, you talk over.
You're right, Judge.
that is not the full contents of all the video for that day, no.
And who decided to participate in, for lack of a better word, editing or picking which versions and how they were obtained? Who did that? Did you do that? Did the IT person do it?
No, I looked through all the video footage.
And you picked those to bring to court today, right?
I notified the prosecutor's office of my findings.
Okay. And your job is to participate in people that are arrested and participate in coming to court and participate in getting convictions. Do you agree with that? You're not
The
here.
question is argumentative.
That's not argumentative. How's that argumentative, Judge?
Your job is in getting convictions.
Well, what's he doing here today? Is he working for me and saying
I
she's
think what he's
innocent?
doing is telling the truth.
Okay.
That's his job, so in that regard, the objection is sustained.
Okay. Do you come to court to testify in criminal cases in your history of being a police officer to prove the innocence of the accused?
The same objection, Judge.
It applies.
All right, thank you. I'll withdraw, Judge.
No further comment.
Any more redirect?
Briefly, Judge. Detective, you said there are other videos of this, correct?
Yes,
Do they present as one long 6-hour video or however long?
they do not.
How do they appear on the system?
So on the system, they are motion activated. So each time it triggers, it creates a new video. So for that complete day, on that DVR of all 4 cameras, I believe roughly approximately 460 video clips.
They're all short
They're
video
all,
clips?
absolutely all short, maybe a minute long.
You didn't edit down a longer video into short clips.
No,
This is how they came to you.
yes,
Did you make any alterations to the videos?
no,
Nothing further, Judge.
Detective, you're not showing any videos from 6 in the morning, am I correct?
correct.
And there were activated videos, motion activated from, let's say, 6 in the morning, do you think? Or is this the only time that she walked around?
No, there were other videos of her walking around.
No other question.
All right, may this witness speak to you.
Yes, Judge.
Thank you.
Thank you.
Next witness.
Judge, we want no further witnesses, we rest our rebuttals.
All right. Here's what we're going to do, ladies and gentlemen. We're going to take a short break, like about a 10-minute break.
People of the state of Michigan versus
You've now seen all the evidence in her heard all the testimony that you're going to hear in this case. I told you at opening that I'd come back here at closing and go over the evidence with you. There are some photos that the people did not show during the case in chief. Those will go back with you into the jury room. If you feel like those will be helpful in rendering your verdict, you're free to look through them and review them. The same with the defendant's interview. The people did not play that in their case in chief. The defense didn't elect to play it. I think the parties all felt it didn't move the needle too much one way or the other, but you're also going to be free to view that back in the jury room. So what has the evidence in this case shown? It showed that Diane Medina, Leah Stith, Ed Smothers, Jaden Phillips, and Mariah Dodds were all injured as a result of the defendant's operation of the motor vehicle. We could bring up the jury instruction on OWI causing serious impairment. And you'll have this written back in the jury room. But the injuries being the result of the operation of a motor vehicle is one of the elements you need to find. That is not in dispute. The defendant was the factual and proximate cause of those victims' injuries. Further, those injuries rose to the level necessary under the law for you to find that element in counts 5 through 9. This is actually stipulated to by the parties. In other words, we agree the degree of injury is not in dispute. Further, we bring up OWI causing death. The evidence shows that Zane and Alana Phillips died as a result of the defendant driving that day. Their death was a factual and proximate result of her operation of the motor vehicle. They do not dispute this. You did not hear from a medical examiner because the parties agree that that was the cause and manner of death. It is not in dispute. The defendant's willful operation of the motor vehicle is not in dispute. The parties agree. We all saw the video of her leave her house and get in her car.
Judge, I agree that there's willful use of an automobile. I just said we agree on willful.
No, fair enough. I guess.
I agree there was an automobile accident. It's proximate cause of a horrible thing of injuries and deaths.
All right, your objection is fine.
People offer to you that the proof show that the defendant willfully operated the motor vehicle on the date in question. You all saw the video of her get into her vehicle and drive it away from her home. We think that element is met. Her identity as the driver of the vehicle is not in dispute. People would offer that there are two key elements in this case that are in dispute: the defendant's blood alcohol concentration and her intent when she crashed into the Swan Boat Club. As to the BAC, the blood alcohol concentration, you've heard from several credible, experienced, and dedicated professionals about the level of care and the quality that was taken with defendant's blood draw and the subsequent testing. You heard from Deputy Schmidt, who was able to walk you through the blood draw process and confirm that everything was done according to proper and long practice procedure. You heard from Rome Monday, the phlebotomist, who testified she had conducted thousands of blood draws in her career, and she also told you she followed the correct, proper, and accepted procedures. Former Deputy Krieger, lab technician Hopner testified. They both told you that not only were the policies and procedures followed, but they went above and beyond. That typically a blood sample would be dropped in the mail. This one was hand-delivered by deputy to the Michigan State Police Crime Lab. Finally, our two experts in forensic toxicology, Tabitha Faust and Samantha Beecher, testified the procedure for testing the blood and their results. Their results, that the defendant's blood was a 0.18, more than twice the legal limit for regular OWI and exceeding the limit for high BAC OWI. Further, there was the presence of gabapentin in her blood. But this is disputed. So what can you folks do? What other evidence can you look at to support the expert's evidence of the blood draw? First, you can look at the testimony from the first day of Ms. Sigler and Mr. Wickland. Ms. Sigler testified that she smelled alcohol on the defendant immediately after the crash. Mr. Wickland flat out called her drunk when he helped pull her out from behind the wheel of the car. He further testified he smelled alcohol on her as well. Deputy Karina said she smelled of alcohol, and Deputy Schmidt went through the field sobriety testing with you in his opinion, she failed field sobriety testing. But how else do we know the blood alcohol result was accurate? We know because she told us. We could bring up the first clip from Deputy Farina.
To 10, 0 being like your so-called sober, you can drive perfectly. 10 being your pass out drunk. Where do you think you're at right now? 7. A 7? Okay.
What else supports it? When they tested her blood, they found gabapentin in her blood. What did she tell us about her gabapentin?
Run through the medications that you told me about again.
Gabapentin,
When do you take your medications today?
8 o'clock.
8 a.m.?
Yeah.
Oh.
And how do we know she had more than the one drink at Furnace? It's well established in the evidence, and I don't think either side disputes. She left Furnace at the latest at 12:15. Crash was at 3:01. But remember what she told Sergeant Bomia.
A little bit?
A little bit, yes.
Okay. When's the last time you had something to drink?
Probably half an hour ago.
Half an hour? What do you drink?
Wine.
Okay.
And just today, you heard from the clerk at Fermi 3, and you saw the video from inside the defendant's house. It's true that she had one glass of wine at Furnace. That doesn't speak to the rest of the day. All of those other pieces of evidence that I've just talked about, just showed you, work together to show beyond a reasonable doubt that the drink at Furnace wasn't her first or her last drink of the day. It's similar to the mystery story I mentioned to you in voir dire, that all of the evidence lines up to show one result, except one thing. And that one thing is defense's expert. But everything else works to show that the BAC result is accurate and in line with what she did that day. The second element that people believe are in dispute is the defendant's intent. We bring up the second-degree murder instruction. For the OWI causing death and the OWI causing serious impairment, you only have to find willful operation of the vehicle and that her blood alcohol exceeded the legal limit, or that she was intoxicated, or that she was impaired by alcohol and gabapentin. For the people's first 2 counts, the 2 counts of murder in the second degree, you have to find a separate intent. You can find one of 3 kinds of intent to find the defendant guilty of second-degree murder. You can find that she intended to kill. You can find that she intended to do great bodily harm. Or you can find she knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of her actions. As we talked about in opening statements, you can look at what she said, you can look at what she did, and all the evidence and circumstances surrounding this case that you've heard over the last 3.5 days to decide what her intent was. You can think about her driving toward the boat club, straight as an arrow, right between those 2 telephone poles. You can think about what she said to Kristen Sigler right after the crash. Where's Don? She wanted to know where her husband was. You can think about her crashing into the neighbor's truck. And then continuing on her way. At the moment she crashed into that truck, she had to know things were not right, but she continued on. She continued on at full speed and drove her car into a 3-year-old's birthday party, into a building, a route that she knew very, very well. Ladies and gentlemen, this is not a typical drunk driving crash. Not at all. She didn't cross a center line and strike oncoming traffic. She didn't misjudge a red light and rear end someone. At almost 45 miles an hour, she drove through the wall of a building that she had been to countless times. That's what makes this worse than OWI causing death alone. She drove her car into an occupied building knowing she was unfit to operate a vehicle. And if she didn't know she was unfit to drive when she got behind the wheel, she knew it after she hit her neighbor's truck. Who started? Five, 4, 3, 2, 1. 44.3 miles an hour on a dusty, pitted dirt road. Look at all those things to determine her intent. As most criminal trials are, the focus of this trial has mostly been on the defendant. How she drove, the contents of her blood, and her state of mind. But let's not forget, a trial is about a fair trial for the defendant and for the victims. The ones you heard testify and the ones you couldn't hear testify. It's about an 8-year-old big sister and her little brother. 2 little kids that had just sat down to eat their hot dog and a cake pop at a birthday party. Sat down to have some lunch without a care in the world. They didn't have a chance. It's about justice for these 2 kids. Thank you.
Thank you. Mr. Close.
This is, the law in Michigan says that the plaintiff, the prosecution has the burden of proof. That's why they get to go first. That's why the defense goes second, because they don't have to prove anything. These people have to prove everything, every element beyond a reasonable doubt. And then because they have such a high burden to prove their case, they get to go first for a closing argument, that's what this is called. And then I do my closing argument as a defense. And then because they have such a high burden of beyond a reasonable doubt, they get to go again. They get to go last. So, and it's sort of common sense. We can't keep going on and on for many days. So they stop it there at the law. So they get to go first, then we go, and then they get to have closing argument the last. And sometimes what happens is that they'll do their closing argument, and then they'll say something that I can't rebut or I can't stand up and talk like I am right now. I'm going to be doing with what they mentioned. So I ask all of you, when you go into the jury room to deliberate, think about what Bill Clovis would have said. Think of how I would have countered anything if they're holding anything for their last time to talk to you and I have to just sit there. This case, I don't have to tell you, it's very, it's very sad. It's very, very sad. And the facts of 2 children passing away, as the prosecutor said, in a setting like this is just beyond grief. And that's why I took a moment out, maybe took my attorney jacket off, so to speak, and really gave sympathy to mom, give sympathy to all of them. I don't want anybody hurt. I don't have vindictiveness. My client doesn't. And I gave my sympathy. And it's normally out of line to do that. And I'm glad the judge and prosecutor allowed me for a minute to do that because I just had to get that off my chest or myself because I can't talk to the witnesses here when we're in court. And they don't have to talk to me at all. It's very, very sad. And, you know, I'm taking a little bit longer in a closing argument today than I normally do when I have a trial or I'm involved in a trial. Because there are several counts. Well, first, all due respect to everybody injured and the poor little kids. I show them respect. And that's why I want to just talk to you. I'm not making things up. You know, so many times, you know, attorneys, people raise their eyes or look up when you say attorney or attorney jokes and that. There ain't no joke in here. And I'm a real deal. When I talk to you, I'm not making anything up. Certainly, it's up to you. You're collectively the judge of the facts, all of you. And so, and I respect that. And my client respects that. That's our American jurisprudence, our American law. is that we have, if you're charged with a felony, especially a capital felony, 12 jurors decide the case. So the judge certainly has been very nice and will release one person, or the clerk will. And then the 12 of you, whomever you may be, will deliberate and rule on the case as a judge of facts. Of course, the most serious part of this case is second-degree murder. Murder charge, don't get no more serious than that, at least in Michigan. A murder charge. And to me, in the law, is that for somebody can get charged every day for whatever. Somebody to be convicted of murder, whether it be second-degree murder, there's an intent. There has to be an intent, or intentional, like recklessness. To me, that's intent. Okay? If I'm driving down the street on the freeway and Bill Clovis never had a heart attack, and I have a heart attack, and somebody's changing their tire, and my car hits them and they die. There's not much intent there. I had a heart attack. What do you want me to do? I apologize. Everything that happened, but please don't charge me with murder. Okay? And that's our first part of the poor 2 children that died. And my client, actions speak louder than words. My client, the officer says, in effect, had no record. Well, nothing.
Objection, Judge. I think he's arguing with facts, not evidence.
Well, I thought I asked the officer with regard to record. If I didn't, the jury heard me not ask him that.
All right, we'll allow it, but it's
Thank you.
a close call.
Thank you. This person doesn't drive around committing crimes. Here's this person that went to lunch. Let me back up. I want to address everything he brought up. But it's interesting that some of the things they brought up was not what they call a case in chief. In other words, when you present a case, the prosecutor, you put everything up there. Then the defense puts, if there's any evidence they want or whatever to counter it or bolster their defense, then they go up there. That's how it's done. Then they waited and did some rebuttal and pulled things out of wherever. Why did they bring that in a case in chief if it's so true and so positive? Something to think about. Is it lawful? Yes, they can do that in rebuttal, but think about common sense. That's another thing. You don't, a lot of times judges will tell juries, you don't leave your common sense outside. You leave your bias and prejudice outside, but not your common sense. You can have your common sense when you're in the room. That's what we all have, our life histories that we bring. That's why I like to have a little bit older jurors, because they've experienced life histories. And they can judge things because they've lived some life. And you can use that. You just can't have prejudice or bias. You can't have that. Somebody's in a defense table, they're guilty. Prosecuted my brother. I don't like prosecutors and police. No, you can't do that. You got to start with a clean slate. Just as if anybody, family member, whatever, is being charged with something. You want them to have just a fair, clean slate you start with. That's why I asked in the very beginning. There's nothing been said. How would you find the person? Sometimes people say, well, they're charged guilty. No, not in America. They haven't put any proofs on it. They got to prove their case beyond a reasonable doubt. Every element. With regard to going, and they held for rebuttal, this Fermi 3 or whatever party store, corner store, and there's this, she bought some stuff for the house, some wine and these 4 little bottles of whatever, Sutter or whatever. There's nothing illegal about that. When she went in there, I asked, is she sober? Is she okay? Yes. Would you sell to somebody under influence? No, thank God. I'd like to hear that. And okay, so we've got that they brought. And then we've got her going at 11 o'clock to Furnace Tavern. Okay. Did she drive there okay? Yes. Did she have an accident? She turned the corner, go down the road, country road, veer to the right. Everything go okay? Looks like it did, or else the officers would be telling us. They're telling us anything. They went and looked at something she bought at 9 o'clock or 9:05 in the morning. So, okay. So if it doesn't exist, that's a positive for my client. Remember that. They're going to bring up every negative there could be. with a microscope. That's why there's two attorneys in there. We're going to bring up positive or talk about their negative, credibility wise. So, okay, so then she drove at about 11 o'clock to Vernus to meet two friends for lunch. She says a sandwich. They say no. Sandwich, you'll see the receipt as an exhibit. Take a look at it. Looks like my client had a better memory on the food part. And so she had the chicken chili or whatever. And she also had one glass of wine. And Vernus, the person, Kelly Horton, that came here, and I'm told that she's like really a peppy person, but she was very sick that day. And she was, and it showed. She did not feel good. And I'm glad she showed under subpoena. And she testified that she was sober. When she came in, she was sober. So if the prosecution is trying to say that she guzzled all these drinks and then went in there, you're wrong. Actions speak louder than words. You can talk all day long. Prosecution wasn't there. The police weren't there. All they're doing is surmising. And they're trying to surmise beyond a reasonable doubt. And they're trying to throw out facts like these two children passed away at a party. Absolutely. I feel horrible. That doesn't make somebody automatically guilty. You have to prove it. We don't go by emotions. So she comes in. The testimony of Kelly Horton is she's sober when she comes in. It's just normal. She met friends, had lunch, had one glass of wine. Any other wine? No. Anything else to drink? Water. Okay. And the bill, she got the bill. They each got individual bills, whatever was paid by credit card. Thank God. There's a record of it. Exactly what my client said. And when I first met my client, she said, I had one glass of wine bill at Vernus when we were in Vernus, because I said, what did you have at Vernus? She said, one glass of wine. And as a defense attorney, you listen to clients, but until it's backed up with something, either paper or something, you don't automatically, I hear it. I keep it in my head, I hear it. And then when I see the search warrant that they immediately used, closed it off, nobody allowed in immediately, because she told them, I went to Vernus, where were you before? Vernus. They went there, they use a search warrant immediately, and they get the receipt. And you'll see that's one of my exhibits. I only have like 3 exhibits, A, B, and C. I keep it simple. And that's one of the exhibits. If you take a look at the defense exhibits, got a little delta or a D at law school. That's what we use. And so that lines up perfect. She's trained, she said, for 20 years. She has regarding alcohol and looking, observing, and the effects of alcohol and seeing if somebody might be under the influence, not to serve them. And she didn't. And she felt she was totally fine. When she left, was she fine? Okay. What did she buy? What did she drink extra? Nothing. Okay. So we know that's solid. We know that before 11, it's solid sober. Then we know at 12:15 when she left, solid sober. In America, in Michigan, you're allowed to have a glass of wine. You're allowed to have a glass of wine. And she ate. Okay. And she just miraculously was able to drive home and go through the country road and branch off and turn and take the angle and do all that, not get stopped, not have a collision, not fall off the road and go into, areas that are not the paved road. And she was able to park her car. These are all things of sobriety. That's what we look at. Wasn't parked on an angle. She didn't hit people coming home, hit people, the neighbor. So then she gets home. She's home for a couple hours, let's say 12:15. She goes up to the birthday party at 3:02 or thereabouts. She was leaving 3:01 in the afternoon. So 12:30, 1:30, 2:30, about 2.5 hours. Then they say there are proofs, and they wait that video. They wait until rebuttal, not their case in chief. So I don't know what was in their mind. That's up to you. I don't know if they thought that maybe it's not as strong or doesn't make sense, but they waited till rebuttal. That's up to you. That's your area. That's your bailiwick. Okay? It's all about credibility. And so that's when they bring up and say, well, look at what we found. Look at what, we got a video here. Let's call, the officer back up here and talk about a video that shows that she's walking around. Okay? She's got that, whatever. And, maybe she's drinking. Okay? All right? And then she's not falling down. She's not tripping. She's not dropping things. But, maybe she's under the influence. Well, maybes don't convict. Maybes not beyond a reasonable doubt. We don't do that here in America, maybes. We don't send somebody away. Murder too. Maybe. Okay. So then this collision happens. And you say, you know what? That was just crazy. Okay. You're right. It was crazy and completely out of character. Somebody's never had anything. And that makes me think that something neurological, that there's been talk, and that she went back while driving out of the driveway and went in reverse. She hit, and then hitting the arm came back, went full speed ahead. And they're saying, the prosecution for a murder too, that she intentionally did this, that she had this intent, this reckless intent to kill somebody. Okay. Former Commodore. Reckless intent to kill someone. I swear, and I swear, there's no intent to kill anybody, much less two little kids. There's no intent to hurt anybody. Why would you put it to the floor? Why would that person testify that it's brake and gas for a second there? Both. Where'd that come from? So, when I'm working on this, I put a lot of days and hours in. When I'm working on this at my office, I'm looking at just don't make sense. Out of nowhere, somebody's going to put it to the floor. Somebody's going to put it to the floor and go right into a building that's 450 feet from her house. She's a former Commodore. She lives on the street, lived on the street forever, married, whatever, a long time. So they're
that bad equipment that Judge Nichols says. Good.
People don't understand the court reporter has more power than the judge, because when that goes out, the judge has to stop too. That's true. I know. That's why we treat them with great respect. This sort of lost there for a second. Put it to the floor, and she's going to, they would say, is that she intentionally caused this recklessness. She intentionally wanted to go into the building. I don't know where that comes from. I have no idea. Yes, I understand what the video shows, but an intent to do that, that's insane. That's crazy, with all due respect. So then, while I'm working at my office and I'm going through things, we start getting voluminous records. And, you were told it was, I don't know, I thought it was 200 pages, but he says more like 300 pages, of going through all the records of the state of Michigan and their history and their certification of the machine and this and that, and also all the records of acetone and all the other things that show up. And it's interesting that, and this is real pivotal part of the case, is you want that blood to be as pure as humanly possible for testing. Why? You got murder too, 2 charges. You have other charges that are extremely serious, under the influence causing serious injury. These are all very serious charges, very serious felonies. So you want everything right on the money, absolutely as perfect as human can be. So why would I not? It doesn't cost a penny, and you do it every day with drunk drivers. As a road patrol officer, why wouldn't you take into the station, get a breathalyzer blown? It's also closer in time. Have that done. It doesn't cost anything. Then you got the data master, whatever they were using back then, the breathalyzer. Okay, you got those results. They print out right then and there, not an hour, right then and there, immediately when you're blowing. 2, to confirm the first. If they're too far off, a third. Why would you not want to do that? Number 1, you've got fatality. Okay. Number 2 is, why wouldn't you do, and he talked about a urine test. I'm not saying you got to do one of those, but at least a breath test, but you could do a urine too. That's what the law says. That's what that DI 177 that he talked about, that he read, which means the right to refuse it, but you can take all these things. My client says, yes, sign. You don't even need a warrant. They got one anyway. I'll sign. You can take whatever blood you want for testing. Does somebody guilty do that? Does somebody feel guilty do that? Somebody scared and they're under the influence, do you do that? And I'm talking about to be a 1-8. Does somebody sign and say no? Or yeah, go ahead and take my blood or my urine or whatever? No, I don't think so. Again, we can use our common sense on this. So they do that and they wait, is it a couple days and take it to Lansing. And then I'm very thankful they have a video of the person drawing the blood. And you know what? That speaks for itself. All of you saw that. And that's why there's 12 ultimately, because sometimes you catch something somebody else didn't catch or whatever and talk about it. And what's really great is you can ask for those videos from the bailiff to the judge for any of those videos. So they'll be, the judge put together a very nice exhibit list of the videos. So you don't have to look at all videos. You can pick out what you want to see, which is good. And so you'll be able to see, did she shake it? Did she invert it 10 times? Because it doesn't cost anything to invert it more than once or twice. But I sort of, with all due respect, I sort of got the gist from her that she was okay with the prosecution, but if I started asking her anything, it sort of went downhill the attitude-wise. I don't know why, but I have no idea. I thought I treated her very nice, but it just seemed like she was not happy to be here anymore. And all I did was ask some questions. But that's up to you to judge that, because you can judge credibility, attitude, truthfulness. You can do all that. That's what you are. And so when I started asking her, well, you know, whatever, and she said a few times, whatever, and then I said, well, you know, the video showed one or two, it was done, and wasn't even done like that. She said, yeah, okay, so, you know, sort of truth serum comes out when you tell somebody, well, there's a video and it says this, what do you think now? Well, yeah, it was one or two times. Okay. So that's done, and the preservative is extremely important. Why am I hitting this so much? Because that's their case. Again, that's why I said, why not take a breathalyzer? And that. Nobody says not to do blood. If you're gonna do blood, do it correctly. It's very important. So it sounds like she does, like she said, hundreds of thousands or whatever it was, and she just, you know, it's another day here, whatever. Well, there's 2 murder, 2 charges, by the way. So that's done. It's packaged and it's driven up a couple days later, or whatever it is, and it's tested. And testing it, and they agreed, the toxicologists or whatever said, you know, your test results are only as good as what you're testing. If it's polluted or it's not good, then your results are not good. Yes, they can come in all day long and give sworn testimony and say, it was a 0.18. I don't doubt that. I don't doubt that that was the result. But how did you get the result? Was there a problem with the fermentation? And something that really sticks out, other than, well, you didn't shake it, so there was fermentation, and here's Bill Clovis, he's coming up with something off the wall, that it's too many maybes there, and it won't overcome beyond a reasonable doubt. No, we've got proof positive. Very thankful that they have proof positive of a graft. I want you to take a look at, I believe it's Defendant's Exhibit C. I believe it's C. I only have 3. So take a look at that, and it'll show that it's more than a little bump. Take a look at it and see if it goes up like this. Acetone, that gas came out. And then they'd have you believe the state of Michigan says it's okay to have acetone. It's all right, that commercial cleaner. A little bit of that doesn't hurt you. Insane. I mean, come up with something better than that. But it's okay. Nobody gets hurt by that. Oh, okay. Have you done ever testing on live human beings with acetone? I don't expect they have, at least this generation. So acetone, and then my person, who to me came across very professional, very, in my opinion, you're the judging on the credibility of people, was sharp. He was credible. He wasn't sarcastic. No matter if the prosecution or myself asked questions, he was honest. And acetone, he said, you know, nail polish remover. That's what acetone it's made up of, industrial solvent. And what happens is Nobody says anybody put that in a blood sample, but it occurs through fermentation. It occurs that way, or something was polluted. The needle, before it went in there, had something, a microbe or whatever. We don't know. But I don't care how it got there. It shouldn't be there. It shouldn't be there at all. And if it's there, it just spoiled the results. These results are supposed to be positive and clean and accurate. You know, accurate, in my opinion, you're the finders of fact. Accurate, in my opinion, accurate is out of 100%. You can get it up to like 95. That's accurate. You start going below that, there's a problem there about accuracy. It's not a 51%. To me, that's not accurate. Okay. Again, we draw it back to murder 2. 2 charges of murder 2. And operating under the influence causing death. And operating under the influence of causing serious injuries. Counts there. Alcohol has to be right on the money. And I know I repeat a couple things, it's just because of the seriousness of this case. Please excuse me. Where's the breathalyzer? Wouldn't it cost anything? Wouldn't have it been amazing if the breathalyzer said 0.01 or 0.02 and they're claiming 0.18? Boy, they'd have a lot of questions to answer. But you know what? The less testing you do, the less tests you have, the less defense attorneys have questions to. Right? Right. So we don't want to have too much. Plus, remember, they're the ones in charge. You can't say, you know what? I want to go here. I want to go to a doctor. I want to have this or that. You can't say that. Why didn't they have the hospital do it? They had insurance. Why didn't they have the hospital draw some blood? Just for the heck of it. They have to worry about transportation, fermentation, nothing. Boom, it's done. Oh, by the way, I forgot about refrigeration. And it's supposed to be refrigerated. Might have an expiration date, but milk does too. And if you put it outside, not refrigerate, guess what? Who cares about the expiration date? It's spoiled. Spoiled milk is the fermented. That's literally, it causes curds and stuff. I left some too long in my office and it stunk up the office and the refrigerator. Baking soda had to be put in. So, you know, fermentation is a very strong animal. It's very strong and it's aggressive. And you don't want that because you've got all these serious charges, including murder too. I want to know, if I was on a jury, that everything is properly done and there's no question whatsoever. And beyond a reasonable doubt, it's pretty close to that. That where we're at is that there's no question that it's there. All the elements are there. Everything was done properly. If things were not done properly, please don't feel that the seriousness of what occurred, I can't say not guilty. That's not fair. That's not what the law says. The law says for you to do your job, do your duty as a citizen, as a sworn-in juror. And that is, if you feel that somebody's not guilty of all the elements and the people have not proven it beyond a reasonable doubt, all the elements crystal clear, then your duty is to say not guilty. And you say, oh my God, these people are going to be mad or they're going to say this. No, you don't do that. In America, you rule, just like the judge has been ruling. He rules. You rule too when you deliberate. Please. Your decision is going to affect my client's life. And I know by looking at all of you, and I've had a few trials over the years, that you've taken this very, very serious. Very serious. And I truly mean that, or else I wouldn't say it. I've had a few juries, and actually, honest to God, some people will start nodding out. They'll start going to sleep. And it's like, I got to speak real loud to wake them back up from over here. And that's sad. That's really sad. And this was supposed to be a long trial initially. You know, picking a jury, you don't know if it's going to be 3 hours or 3 days. And we moved along very well. Everybody came across very honest. I think that's how we were able to do it. Plus, the judge is really good, if you haven't noticed, about keeping us reined in and moving the case along. I love that he starts at 8 o'clock because I've been in other courts at 8:30 and they show up at 11, the judge. So this one I can count on. That door's going to open at 8. And that's good because it's taken a lot of time out of all of our lives, but more importantly, we do this for a living, out of your life. And I truly want to say thank you. And I truly say thank you for being here, for uprooting your whole lives. I don't care if people are retired at home, you're still uprooting your life. And lastly is that we've put such a heavy burden on you. We have a very heavy burden on you when you make your decision. However you make your decision, I will respect it. But you've got a heavy burden and everybody has to go on living. But I want to thank you again for taking the time out to be here. There's areas I didn't cover just because you listened to everything. You saw everything, the testimony, videos, exhibits. So I'm not going to go through every single piece. I've gone through enough, but it's my one time. I don't get a second time. If he does go up, Mr. Lorraine or whomever, please try to think what Bill Clovis or the defense would say, encounter it. Okay. Thank you very much again. I appreciate your time today.
Thank you, counsel.
Brief rebuttal.
Absolutely.
Folks, I don't have a long pre-planned rebuttal or anything like that. I'm sure you're happy to hear that. Just like to hit on some things Mr. Clovis spoke about in his closing. Why didn't we play those videos and bring the Fermi clerk on before rebuttal? Because that's not how the prosecutor's office proves drunk driving. We prove drunk driving through the blood result. Once Mr. Clovis wanted to challenge that, I have what I believe to be other evidence of alcohol consumption. I'm going to play that for you. I'm going to show that to you. If he hadn't presented a case, I wouldn't have presented that evidence because I had a blood result. I agree with him that actions do speak louder than words. Her actions at Vernus. But that's the testimony of a waitress who saw her for a minute at 11 o'clock. I think she testified about 3 times that she did not see her leave. Countered with the testimony of a bartender who saw her immediately after the crash, and 2 police officers who dealt with her. Police officers specifically trained in spotting alcohol consumption. I also agree with Mr. Clovis that maybes don't convict. They do not. But you know what does? Lab results, videos, injured people, and deceased victims. The intent in this case was sealed. The second she put that car back in drive and continued down the road. He characterized it as intentional recklessness, but it's exactly what is written in the jury instruction. And look at that. It is creating a situation. Once she starts to back out of her driveway with that blood alcohol content, that's the beginning of it. If she had run someone over right then and there, that's OWI causing death. What she did, that's second-degree murder. She knew from that second she was dangerous. She was in a situation where she was creating a high risk of death, and she continued on anyway. Mr. Clovis talked a little bit about beyond a reasonable doubt. The judge will explain to you what beyond a reasonable doubt is. What the jury instruction says is it's a doubt that grows out of reason and common sense. It's a doubt that grows out of the evidence or the lack thereof. So again, as I did in my opening statement, on behalf of the victims, on behalf of the people of the state of Michigan, when you go back in to deliberate, I ask you to look at everything, speak amongst yourselves, deliberate as you see fit, and when you're finished, find this defendant guilty of 2 counts of second-degree murder, 2 counts of OWI causing death, and 5 counts of OWI causing serious impairment. Thank you, folks.
All right, so that is over for now. Gosh, Mr. Kolovos, gosh, talk about a snooze fest. I get he wanted to, wrap things up, but usually closing is where you kind of get the jury, like you put everything in a little package and you drive your points home. I don't remember, maybe I was, nodding off a little bit. I don't remember him mentioning anything about her neuropathy or her legs seizing up or her passing out while driving. That was his main defense, was her health, and no witnesses related to her health. closing, I mean, and then talking about the like spoiled milk in his office. Like, come on, buddy. It's kind of like you want to like just drill your points into the jury and you want to end with a bang, so to speak. That was very lackluster. Like, in my opinion, he tried, but I think he should have taken a different angle with it. And like a lot of you said in chat, she should have made a deal or pled guilty. Make a deal, because she now, depending on the verdict, and actually I'm going to do a poll before we see the verdict. I'm going to make a poll. Give me 1 second. My internet is going a little slow. So let's see, how do I, the verdict will be, so we have guilty, oopsies, guilty or not guilty. And we're going to go with the murder charges, because I think that's where a lot of us are struggling, is whether or not the prosecution proved intent. So let me start that. So I'll give a few minutes to vote on that, and then we'll get into the verdict. So my jury duty, I'm just going to remove this for a second. My jury duty, it was an accident case. A woman was suing the other driver for $500,000 for a 1/2-inch scar on her face that she had sustained in the accident. So, in short, it was a winter day. The roads were snowy. The one driver, the defendant, or I guess it wouldn't be a defendant. It was civil, not criminal. So the respondent, I guess that is, the respondent was driving, ended up sliding off the road and hit the other lady's car, causing her car to also go off the road. Both refused medical treatment. They exchanged information, went on their way. Well, then the lady who, was hit, and it was truly an accident. It was snowy roads, like, stuff happens. So we actually found for the respondent, and I remember there was one older guy in the room with us, and he said, could one of you punch me in the face so I could sue you for $500,000? And it was the most egregious case ever. And the fact that it in my opinion, it was a waste of the court's time, our time, money. They were showing photos of her scar, and we couldn't see it. We could not see her scar. So, needless to say, it was a quick trial because there was not a whole lot. Okay, Velda, you've seen the verdict. Okay, well, that's good. I'm glad you were honest with that. All right, so let me end the poll. Hopefully everybody was able to vote that wanted to. All right, so we have 3 people voted. And so 3 say guilty, none guilty. And I know the verdict too. Unfortunately, I tried my best not to see the headlines. Yesterday, I was sharing Sinners Live, And as I was doing that, the video underneath his, when I was sharing, was the verdict. I'm like, come on. So I know it, but we're gonna watch it together because I have not watched the actual jury delivering their verdict. So let me add this back. Hopefully the closed captioning matches up because it's very hard to hear sometimes. Zoom.
Marcella Chester.
All right, ladies and gentlemen, we have a verdict. I know this has been an emotional case, one of the most emotional cases that I've been involved in, but we're still in a court of law. You guys have been great all week. The media has been very unobtrusive all week, and I appreciate their efforts. But remember, once the verdict is read, we're in a court of law, and we would act accordingly. All right, Bill, if you can bring in the jurors. All right, ladies and gentlemen, welcome back. I'm told that you've had a verdict. Is that correct? All right. You're the foreperson? Yes. Would you please stand for me and read me the verdict form? You're going to say, "We, the jury, find," and then you'll go through each count, please.
We, the jury, find as follows. Count 1, guilty of murder in the second degree of Alana Grace Phillips. Count 2, guilty of murder in the second degree of Zaid Isaac Phillips. Count 3, guilty of operating while intoxicated or operating while visibly impaired, causing the death of Alana Grace Phillips. Count 4, guilty of operating while intoxicated or operating while visibly impaired, causing the death of Zane Isaac Phillips. Count 5, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of the body function to Mariah Lynn Dodds. Count 6, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of the body function to Edward Thomas Smothers. Count 7, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of the body function to Jaden Bryce Phillips. Count 8, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of the body function to Leah Marie Stiff. And count 9, guilty of operating while intoxicated or operating while visibly impaired, causing serious impairment of the body function to Diane Virginia.
All right, thank you. If you would put that back in the envelope and then just give it to my bailiff. Is this everyone's verdict? Yes. So say you won. So say you all. Yes. You wish me to poll? All right, I'm going to point at you. I'm not being rude. I just don't want to publish anybody's names. Okay, so I'm going to start in the back row and say, is this your verdict? Is this your verdict? Yes. 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 Is this your verdict? Is this your verdict? Yes. I'm going to come all the way here. Is this your verdict? Yes. Is this your verdict? Yes. Is this your verdict, sir? Yes. Is this your verdict? Yes. And is this your verdict? Yes. All right, thank you. Ladies and gentlemen, I want to thank you for your hard work. I know that you worked hard all week. It's a long, exhaustive process. Takes it out of you physically. It takes you out emotionally. We really respect and appreciate your hard work. I'm going to ask for one more little favor. And if that is, you would go to the jury room and wait for me for a second so that I can come in and talk to you for just a second. Ms. Keene, would you come around here and join them as they go back into the jury room? All right, thank you. I'll talk to you in a second. You can come, yeah, go ahead. All right, Mr. Chichester, you've been found guilty by a jury of your peers, 2 counts of second-degree murder, 2 counts of operating under the influence and causing death, and 5 counts of operating under the influence causing serious bodily injury. You are to be sentenced in these matters on May 15th at 3 p.m. that will be in this courtroom with Judge Nichols' permission. You are remanded to the Monroe County Jail pending sentencing. We are adjourned.
And remember, the jurors did see some evidence that we did not see. It was admitted into evidence, but it was not shown to the public. Oh, most definitely an appeal. I feel like if there wasn't an appeal, Mr. Kolovos would not be doing his due diligence. Oh, and she has to walk right by the families too. I mean, just still no emotion at all. Curious, I know part of the evidence that wasn't shown to us had to do with the two kids who were killed. I'm not sure about the other stuff. I can't remember. All right. So there we go. She is guilty on all counts. Guilty on all counts. So before we go, I have, what's going on here? Hold on a second. What is happening here? Give me 1 second. I think I messed up my list. Yes, I did. Okay, so we have 3 videos left, short videos. The first one, we are going to hear the prosecution give a quick statement in regards to this case. We'll then hear from Mr. Kolovos, who is the defense attorney, and there's a very short video of the dad of the children who were killed speaking to the media. So we're going to start with the prosecution or the state. Yeah, but I think the judge, I mean, he was pretty, like, we're still in a court of law, you still, but I mean, I don't know, for me, I mean, I would have acted much differently than she did. Well, I wouldn't drive drunk either, but I just feel like I would feel horrible. And maybe she wanted to be stoic and not show emotion, but she was crying when the mom was on the stand. When the mom who lost those children, her and her lawyer both were crying. Yet she doesn't cry throughout when she's told that you're guilty of murder. I mean, maybe, somebody I think had said maybe she knew it was coming and she kind of just accepted, her fate. But yeah, super interesting, Nanny. And for me, it's really, I don't want to say nice, but it is interesting to cover a case when it first happens and to follow it through to the end. I think this might be actually the first case that I've actually started at the beginning and saw to the end. I did see, just on a side note, the mom in Michigan who abandoned her 3 children. She was in court today and her bail was significantly reduced. It was still significant, but she was initially held on a $250 million bond. Her bond was reduced to $50,000 cash, no surety. And she had several stipulations, one including she cannot leave her house unless it is for a medical emergency or I can't remember the other thing, an appointment or something like that. So I plan on doing a short about that though. Yeah, I like trials too, but it's a lot. It's a lot. Like it's draining, even though, you know, I'd be watching it. I like watching it with all of you because it makes it more interesting than just watching it by myself. But I mean, I've been live not even 3 hours, and I'm like, okay, I've had enough for the day. All right, so let's get into these few videos and well, interestingly enough, Good Trouble, her dad currently has custody of her children that she abandoned, allegedly abandoned. We know it's true, but and one of the stipulations was that she has no contact with children under the age of 18, the alleged victims in this case, and the current guardians of said children in this case. So if she were to have daddy bail her out, that would be in violation of her release conditions, and she would possibly revoke her bond. But yeah, I don't think Sinner, I don't think anybody's going to bail her out either. Maybe, but I don't think so. Yeah, me too. Everybody sees something different, and the chat is good too. Yeah, Nanny, it is an extreme amount. But the judge initially, she had a point. I don't remember her first name, but her last name is Bryant. She didn't have, a set address. She was living with someone. They didn't know where she really was. Apparently she's unemployed because the judge today said she has no record of employment. Like there's no proof she's even employed. So I don't know. It's very bizarre. Oh, thanks, Trouble. I appreciate that. All right, so let's get into the prosecution and see what they have to say. We'll get into Mr. Kolovos and then the dad.
Everybody, my name is Jeff Yorkie. I'm the Monroe County prosecutor. I want to thank everybody for coming in today.
Stop, pause. All right, let me slow this down. We'll go back to normal speed because
I have a few points that I want to make, a couple of brief statements, and then I'll open it up to questions for the attorneys and any of the law enforcement officials that are here today. First of all, I want to start out by saying that we are obviously satisfied with today's verdict. We're very pleased with today's verdict. Well, we appreciate everything that the jury did here today. We think that they did a phenomenal job in evaluating all of the evidence, and we're obviously happy with the way it's turned out. That said, there's never any winners in a case like this. There's nothing that we're going to be able to do to bring back Zane and Alana, or to be able to heal the physical and mental damage done to the people that were present at that birthday party last year in April. That said, I also want to thank all the first responders, though, because their quick action prevented this tragedy from being worse than it already was. And I also want to thank the amazing work that Sheriff Goodenough's team has done in this case. I want to thank them for their professionalism, the excellent work that they did in providing us with the evidence that we needed to effectively prosecute this case. Specifically, I want to thank Detective Modelinsky and Sergeant Hooper, who were instrumental. Sergeant Hooper, unfortunately, isn't here today, but Joe Hammond is here. He's our undersheriff. He's helped to coordinate all of this, all of the work that the Sheriff's Department has done, and we just would not have been able to do it without them. I also really want to send a shout out to the State Police Crime Lab for their professionalism and assistance, and specifically Tabitha Faust. She testified today and yesterday and did an absolutely phenomenal job, and I thought it was very important to point that out. Finally, my team, led by Senior Trial Attorney Ken Lorraine, my hat's off to the hard work that was put in by Mr. Lorraine, along with Assistant Prosecutor Chris Marriott and Alexis Hatch. Their job their job is to distill all the evidence and then break it down and present it in a clear and concise and a cogent manner for the jury to be able to understand the theory of the case. And they just did an unbelievable job of doing that. I could not be more proud of the job that they've done. But they could not do it alone. I have a couple other special shout outs to some of the people that work in our office. Missy Nichols was instrumental in putting a lot of the media together that we showed at the trial. Brooke Bazinski did an amazing job of coordinating the over 30 witnesses that were called in this case and making sure that they were ready to go at the appropriate time in order to keep this case moving along. And that's really important for the jury. And finally, also want to thank our victims' rights coordinator, Allie Horkey. She and her staff do an amazing job in a case like this that is as difficult emotionally to have to deal with on behalf of these victims. She does an amazing job with them, and we couldn't have done any of this without the hard work that they put into this, along with the rest of the staff in our office. They've been on the ball for months while we've been working on this case, and we couldn't have done it without any of them. So that's all I have. I want to thank you guys for coming in, and I'll open it up to questions.
New evidence came out today. What did you think of that?
Okay, so that was the prosecution, quick and to the point. The way that it should be, clear and concise. That's what I had said about, the prosecution's closing. It was straightforward to the point. They talked about the evidence, they talked about what was shown, and then we get to Mr. Kolovos, who called the trial one-sided. Well, sir, you were the second side, so it shouldn't have been one-sided. So let's see what he's got to say. Yeah, victim advocates are awesome angels. I agree. And thank goodness for them.
Well, it wasn't a surprise. I was aware. There wasn't any real testimonial evidence, just a video or videos.
Sir, were you at the same trial we were at? Because there was much more than just videos. There was a lot of testimonial evidence, including her blood alcohol content, which I think was the main thing. The testimony of the victims who were affected by her bad decision. Like, come on, buddy.
Which even if you looked at the videos, what is it going to show? Is it going to show that somebody consumed enough to be a 0.18?
But with that being said, she didn't consume the alcohol on camera. She was in some other room. So who knows what else is in there? And then to say that she was recycling the little bottles of alcohol, and that's why it was found in her center console. How many of you put recyclables in your center console? Oh, nobody? Me either. Because when I recycle, it goes into, I have little recycling bins. And, if it's returnable, because in New York, if you return your soda, water, it's, you get 5 cents for returning it. So I put it in a garbage bag. And then when the garbage bag's filled up, I bring it back to the bottle return. I don't stick them in my center console to recycle them. I
So it's to the jurors' interpretation of what they think happened during those hours. What is it?
So he's really hyper focused on the videos of her in her home. Those videos in her home, like, yeah, it was a holy crap, oh snap, but that didn't, even the receipt that she went and bought, and what are the chances that the alcohol she bought on the morning of April 20th were the same bottle, was this, or the same bottles that they found in her center console? I find it highly unlikely to be a coincidence.
Look like? And it was edited.
Yeah,
it was
evidences are
cut
blood.
and paste and put together during certain hours. So certainly we think it's unreliable. The judge allowed it in. I have to respect the judge on all his court rulings. When you lose 8 out of 10 motions, I still respect the system, but I also will file an appeal and let the Court of Appeals or Supreme Court make a ruling and judgment on what the judge did.
Did you expect such a fast verdict?
No, I never expected such a fast verdict of, is it less than 3 hours?
I think less than 2.
Okay, so he said less than 3 hours. The reporter had said less than 2 hours. I actually think, well, when I heard a verdict, because I was live when the verdict came back, and usually when they come back quick, it tends to be a guilty verdict. But the evidence, I mean, there was so much evidence. So much evidence. Yeah, a lot of evidence. So Curious says the most evidence I've seen in a DUI case. I mean, the video surveillance at the boat club, the ring camera footage at one of her neighbors on the corner, like the video of inside, like you actually saw her driving into the building, and then you saw the inside of the building with her driving into it. Like you can't deny. You can't deny. And you know what's interesting, Pookie? He brought nothing in about the gabapentin. Like with the defense's witnesses, they didn't really talk about that. It was all about what is it? No, I don't remember the word, but whatever the nail polish remover is.
And, you know, they say quick verdicts are not good for somebody that's charged as a defendant. It's not quick. So that also concerns me that did they truly deliberate? Was there already a decision in their mind? And it's just, you know.
Wait, let me rewind. So he's saying
that did they truly deliberate? Was there already a decision in their mind?
Well, normally, I mean, at least what I've heard in trials that I've watched, the judge usually says, like take a vote, like take a vote when you first get back. And I'm assuming because they did take a couple of hours that not all of them were on the same page. So they talked about things and came to a resolution. So to question the jurors, that is so disrespectful. They probably did have their decisions when they went into that room.
And it's just
right, blaming the jury. Exactly, Nanny.
And justify the means. Was it that somebody's going to pay, or the defendant's going to pay for the 2 children that died and that car went in the building? Let me get, one little example is I have a relative that said without knowing anything, before even the blood came back results that they allege, said, well, her car went in the building, so she's responsible.
Exactly.
It's not a strict liability crime. And I respect the jury for what they had before them. Some of that evidence, we say, we filed motions, was unlawfully obtained, unconstitutionally obtained. Acting that way can violate a lot of people's rights.
But the thing is, it clearly, I mean, he's probably going to appeal it, but those are the motions that he had brought up at the beginning when the judge was like, why are you waiting until now? You've had all this time. And one of the motions that Mr. Kolovos brought up at the beginning of the trial was the same motion the judge had already decided on. It was just, it just boggles my mind.
You know, that saying that when they come for you and come for this person, that person, you don't say anything, but when they come for you, then all of a sudden you say something. So it was very apparent.
So what he had said at the beginning of the trial before they started was he was alleging that the search of what was it? The blood. It was something with the blood, and that they didn't have a warrant. Something with the blood. And he was saying, you know, oh, that's what it was. She had contacted him, and before he could get to his client, they had already taken her blood. Something like that. The fact that, I mean, I'm surprised they didn't get her blood sooner. It was 3.5 hours after she drove into that building. So I'll have to look to see what his other motions were, but that's the one I remember, because the judge was like, I've already, you know, ruled on it. If you want to put it in writing, I'll look at it tomorrow or whatever.
With the court, I have respect for the judge, but it was very apparent that this was a one-sided case. This was going to be a conviction no matter what it took from all ends, there's going to be.
So is he saying like the jury was bought off? Like they were all in cahoots with each other? Like, yeah, we're going to find her guilty? Like, that's why there's voir dire.
Be a conviction. When you lose 8 out of 10 motions, and they weren't frivolous, and it all dealt with constitutional issues, every one was no, denied. Been doing it 39 years. I've never had motions denied like that.
Did you move specifically to get that video we saw today excluded?
Yes.
Will you have a chance to talk to the jurors?
We could, or I could ask. I'm not going to. You know, they've gone through a lot, and probably one of the last things they want is one of the attorneys to come in. I'm sure they're extremely emotional.
Okay, and so we're just going to take a short little detour. So speaking of motions, I actually, while he was talking, I looked this up. So this was from February 25th. Oh, shoot. What did I just do? Hold on a second. There we go. So it says Marcella Chidester's attorney makes motion to have case dismissed. So the 25th was about a week and a half ago. So Marcella Chidester appeared in court with her attorney Bill Kolovos on Friday, February 21st in front of Monroe County Circuit Court Judge Daniel White in an attempt to get her case dismissed. First, Kolovos made a motion to dismiss the case based on the crash at the Swan Lake Boat Club she was involved in happened on private property. Judge White denied the motion since the boat club's parking lot was open to the public. Wow. I hadn't heard that one. But that makes sense because in part of the testimony, the questioning, they had asked about whether or not the parking lot was public or private. And so that makes sense. The second motion was to question whether or not the blood alcohol test administered to Chidester met the foundational requirements to be considered credible in the case. Judge White said that they would hear whether it was and thus is able to be used at trial, which takes place the first week of March. Okay, so that's all. Okay, so it says, according to a lab report submitted to the court as evidence, Chidester's blood alcohol level on the day of the crash was 0.18, more than double the legal limit of 0.08. Colobos had argued the crash was the fault of a seizure, of which his client had a prior history, and questioned the handling of the blood taken from Chidester to check her blood alcohol content, which that was apparent based on what he had said in court. Yeah, she was drunk when she left the house. It doesn't, and the thing is, it doesn't matter if she was drinking in her house. I mean, I would assume she was, and the fact that she drove to the tavern to meet with friends and then drove home safely, it was probably because it was just because she's done it so many times, and she just happened to not hurt anyone on, the however many times she's done it before, because I don't believe this is the first time she's done it. No. And I had said it in chat, but I was shocked. I must have missed when someone testified that when she got out of the car after crashing, she asked where her husband Don was. And that makes me think that's why she aimed the way she did, because she knew where her husband sat at the bar. That's just my opinion, of course.
Will you have a chance to talk to the jurors?
We
yes,
could.
Nanny. They had a search
Or
warrant,
could
I
ask.
believe.
I'm not going to. I'm not going to. They've gone through a lot, and probably one of the last things they want is one of the attorneys to come in. I'm sure they're extremely emotional. I could tell when they came out that they couldn't make eye contact. And during the trial, I had a lot of eye contact. There was no eye contact at all. In fact, they looked down. I don't think they were happy that they had to deliver a verdict. Not at all. But they felt inside they needed to.
Was Miss Chidester surprised by the jury's verdict?
My client knew going into this case that the jury, to pick from the jury the people, it would be that it would be tough to do because they're so tainted. The community's tainted. I'm not saying you get tainted automatically. When you talk to somebody and you say, oh, 2 kids died. Oh, what happened? Did the car go in the building? Yeah. Oh my God, she's got to be guilty of something. So we had many heart-to-heart conversations, Marcella and I, very many heart-to-heart, including today. And she was well aware that certainly could go either way or split. Our most important issue was the murder 2 charge, because with 2 murder 2 charges at her age, you might as well give her life. And she was aware of what could happen. And she was aware that if it's an early verdict, and, she stayed strong.
Thanks, Bill.
And just real quick, she's been out on bond. And a lot of people were saying, listen, her age, her sentence of multiple years, if found guilty, just leave. Just leave and not come back. And no.
Wow, sir. Yikes.
She stayed, and she faced up to it.
Oh, crap. Hold on a second. This darn thing. Okay, so I did find another article, this was from February 10th, updated February 11th. Judge denies motion to have statements from Swan Boat Club crash suspects suppressed. So when she, remember, a lot of the victims of this had said when she got out, she just kept yelling, I passed out, I passed out, I passed out. So this is another motion that he had denied. So it says a woman accused, okay, wait, the Walker hearing on Monday was to determine if Chidester's statements to law enforcement officers is admissible for trial, which is scheduled March 3rd. Okay, so it was the law enforcement, not the victims. So I was wrong on that. At the Walker hearing, the judge denied Chidester's attempt to suppress statements taken at the crash. Right, because when the one officer said to her on a scale of 0 to 10, where 0 is stone cold sober and 10 is, drop down drunk, where are you at? She said 7. That's pretty drunk. 7? I mean, you're not even on the other side. Like, you're more than half. So Chidester's attorney said the motion is a setback. So it seems like, he was doing what he could to try to get stuff not in trial. But unfortunately, yeah, like, why would he say that? She didn't run away, because then she would have been in even more trouble. Like, of course she's not going to run from this. Like, what the heck, dude? Treble says, I just saw parts of this. He was way too casual about his closing, disgusting to insinuate funny business. Right. It's just, just respect the jury. They did their job. And, he thanked them in his closing, like, I'm so, it can't be easy, da 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 da. And now he's saying, oh, it was, whatever. So the last thing I have for us today is a short video. This is the father of Alana and Zane, the 2 children who were killed in this event. And so I have not seen this, so this will be interesting to hear.
Never truly find peace, but do you feel with this verdict you're able to have some type of peace?
After I leave here, I'm going to their gravesite and let them know how today went. I will never get peace. I never will find peace with this, but I'm glad that the verdict came back on all counts. I am happy with that verdict.
What was it like having to wait to find out what was going to happen?
I have been really patient through this whole thing. I've tried not to show any emotion, that way it didn't jeopardize this case at all, but I'm really, really glad that the verdict came back on all counts. I believe they did get this right. The evidence clearly showed what she did, and she should be held accountable for what she did.
I agree.
I know you said that you're never going to have peace. Do you feel at least like this makes it easier for you to at least close a chapter or anything like that?
I believe, yes, I believe it does close the chapter on this whole trial that's been done. I believe that when I look back at it, everything that came out, I believe that it was right. I believe everything is good. I feel that the verdict is that it came out right. That's all I do want to say. Thank you, guys.
Thank you very much.
Do you see that window right there?
Pause. All right. So justice has been served, in my opinion. And like that dad said, he's never going to have peace. He's never going to get his children back. Marcella still has her life. And for that, she should be grateful. Although I hope that she lives the rest of her life in prison. But at least she'll be in jail for just over 2 months. So I did write down her sentencing is May 15th. So I'm going to actually put that in my calendar right now. So I'll definitely cover that. And I was thinking, because Marcella always makes me think of Stephen Schwally, Daniel Hayden, other cases of drunk drivers who have killed several people. I need to look into them and see. Actually, you know what? What time? Yeah. Actually, let me just look quick. Let me look up Stephen Schwally. Stephen Schwally. All right, let's see. Okay, so a month ago was the newest update for Stephen Schwally. And it just says prosecutors. Come on, website. Why can't I scroll? Oh, because I have to pay. So real quick, it just says prosecutors seek cheek swab to boost DNA evidence against Stephen Schwally in nail salon crash case. Suffolk prosecutors are looking to strengthen DNA evidence they allege show Stephen Schwally drank the 2 empty bottles of 42 proof liquor found inside his car. And in the case of Stephen Schwally, if you haven't heard of Stephen, he drove drunk like a bat out of hell into a nail salon in Deer Park, Long Island, killing 4 and injuring 9 others. And I know they had a trial date. Let's see. His trial date is scheduled for, let me see. Okay, why doesn't, they're saying there was a new court date, but it's not saying when it is. Okay, well, I'll have to figure that out. And then Daniel Hayden is a man in New York City on the 4th of July of this past year, drove drunk, running a stop sign into a park where people were getting ready to watch the fireworks, and he plowed into a crowd of people, killing several. All right, and there are no updates in his case at all since August. That's wild to me. I'm going to have to look at the court records for that, if I can get into that. All right, so nothing to update on Daniel Hayden either. Yeah, appeal could take years, absolutely. But I feel like I don't really think that Mr. Kolobos really has a whole lot to, I mean, I would hope that he would appeal, but I don't think there's anything that, is justified, at least in my opinion. So thanks everyone for being here. This was a long week, but it was good to see this through, and I'm glad that the jury found her guilty on all counts, because she needs to be held responsible, and she was. So for those of you who are interested, Sinner and I are going to be live tomorrow night at 7 p.m. Eastern Time, 6 Central. So I'm not sure what we're going to talk about, but we are going to go live. And I also know that AMAC is going live. Gosh, I think it was 9:30. Give me a second. I'm going to look real quick. Because AMAC hasn't been live in a little bit, so I'm excited. I'm excited to see. Let's see what time. I'm pretty sure it was 9:30. Oh no, 10 p.m. Eastern. Okay, so AMAC will be live at 10 p.m. Eastern, so just a couple of hours. All right, y'all. Well, thanks, Nanny. I appreciate that. So I hope everyone has a great night. I'm not doing an outro because we've been here for 3.5 hours. So have a great night. If I don't see you on these YouTube streets, I will see you on the flip side.